Hi, can the person who just joined by phone with the number that starts 212 let me know who they are and what case they're here for? You can do it in the chat or on screen.
Chelsea, what's the community? Right on the I'm sorry, there's a post-it that says,
Good morning, Commissioner Duson. Good morning, Commissioner O'Brien.
Good morning.
I believe we have a bunch of commissioners, Richard Duson, O'Brien, David, Ashby. I just want to check this phone number here that ends, it's 207 and it ends in 724. If that person can just.
Alice.
That's Alice. Okay, thanks, Alice. Good morning, Mr. Messerschmidt. Can't hear you. You're muted.
There we go. How's that?
That's lovely. Thank you.
Thanks.
You don't have to stay on screen. I just wanted to say hello.
Thank you. And hi to you.
Commissioner David, you have a nice sunny spot there.
Yes, unfortunately, I can't, I can't make it less sunny. I'm just waiting for the sun to climb out of the direct view. But yes, it's a lovely sunny day in Canada.
Is that, I was going to ask, did you finally get there?
Absolutely. I'm sitting here watching the ocean
Oh, great.
out this window with the sun streaming in. Yeah, we got here, I came up August 30th, I think it was. My wife came up the 16th. A lot of rigmarole with getting a test within 72 hours and then getting randomly selected for another test that I
Oh,
had to take home here and do online for a second test. And
oh,
but so it seems like the safest place to be, given what we're reading about Maine.
yeah. Yep. And I've heard there's a huge, there's a shortage. There's not enough tests to go around right now for people who are, I guess, traveling or wanting to confirm if they
Yeah.
do or don't have it.
Right. Well, you have to have a test within 72 hours, which is problematic with the backlog and stuff. You know, you mail one in and they say within 48 to 72 hours, you'll have it back. And we didn't trust that. So we went to South Portland and paid $160 for
Wow.
the urgent care. But you sit there and they'll do it. You can make an appointment. They'll do it. They tell you that might take an hour. They brought mine out in 10 minutes and gave me a piece of paper to take away, and it was very reassuring. But all it takes is money.
Yep, that's about right.
But I'm having a little trouble seeing my screen.
It's too sunny.
Yeah.
And here we have, thank you, Joan. We have Joan is in our offices sitting with the complainant on our first case for the hearing, but we're not ready for the hearing yet. So I'm just going to keep you on mute. I see there's a Betsy Shu here, which is not a name I recognize. If you could just let me know what case you're here for.
Good morning. I am here for the Christina Porter versus CMMC.
Okay. Are you with one of the respondents?
Yes, I am with
Okay.
CMMC.
Okay, thank you.
Thank you.
Morning, Miss Archer Hirsch, and I see Mr. Beauchene, Miss Dumas. Miss Garcia, who I forgot to say good morning to earlier. Martin S., who I don't recognize that name.
Good morning.
Oh, hi.
Samuel Martin, attorney
Oh.
for.
I was like, Martin, I don't know that. Oh, hi, Sam. Okay,
Hi, good morning.
thanks. Nope, that's not exactly what I thought. Nope, I thought you were Sam Riot. Nope, you are, did you say Sam?
Samuel Martin for Matheson Trigas.
Oh, got it. All right, thank you very much. Sorry about that.
No problem.
Hi, Miss Dupre. I always pronounce it wrong. I'm sorry. You are getting connected. I see you there. Hi, Mr. Guerin. I'm going to keep you muted.
Thank you.
Hi, Miss Dupre. There you are. Can you unmute yourself? Do you know how? Is there a button you can hit for unmute just to make sure it works?
Oh, I can.
That's it. That's how you do it. Okay,
Okay.
so you're all set. You're going to stay muted for now, and I will, when it's time for you to unmute, I'll send you a little request, okay?
Okay. How did that pop up? Did you bring that up?
I did that, yep.
Okay. So it's okay. My sister will sit here too.
Yep, that's great.
Okay. All righty. So.
And the person who's in phone number 212, can you just let me know who you are and what case you're here for?
Hi, my name is Lauren St. Pierre. I am one of the complainants here.
Oh, St. Pierre? Yeah, that's
Yes.
totally fine. Just so you know, your case isn't being heard until this afternoon. So you're welcome to be on here all day if you want, but you don't have to be.
I'm not on till the afternoon.
That's right. We
Is
did
that
send,
correct?
that's right. We sent around an updated agenda that told people that there were morning and afternoon sessions and where their cases were.
So what time should I log in the afternoon?
So if you want to log in at noon, you're safe doing that.
Okay, so I can listen now?
You can, yeah.
Okay, thank you.
Yep. I'm seeing some folks sign on. I see Mr. Ho. I'm glad you could join us. Just so you know, your case is on in the afternoon. We sent around updated agendas that show morning and afternoon sessions. So you're welcome to be here, but you don't have to be until the afternoon. And Miss Taylor, can you tell me what case you're here for?
I'm here for the case with Valencia Dumas.
Okay, thank you. All right, Commissioner Whitworth, where did your box go? There you are. I think we're ready to start the business part of the meeting.
Then I will unmute myself. So good morning, everybody. I'm Deb Whitworth, and on behalf of my fellow commissioners, welcome you to this meeting of the Maine Human Rights Commission. Before we proceed with the business of today, I am asking each of you who may have an electronic device, cell phone, pager, etc., to ensure that they're silenced now. There are agendas available online. You would have gotten that information at least a week ago. The agenda includes the consent agenda. The consent agenda is a listing of cases in which no written arguments were made to the commission in the allotted time period. The commission will vote on those cases shortly, and they will not be considered further today. The remaining cases on the agenda today are coming before the commission to determine if reasonable grounds exist to believe that unlawful discrimination has occurred. The commissioners have received and reviewed investigators' reports and any written submissions submitted within the allotted time. No new information or any written materials will be accepted today. So with that, is there a motion to adopt the agenda and the consent agenda?
So moved.
Second.
All those in favor? I know Amy has to call us one by one.
Yeah, and I'm going to remind all commissioners that we are required in any vote for commissioners to indicate their vote both visually and orally, so everyone can hear it or see it. So the motion to adopt the agenda and consent agenda, Commissioner Whitworth,
Yes.
Commissioner Ashby, sorry, I'm a little slow this morning.
Yes.
Commissioner David,
Yes,
Commissioner Dusan,
Yes.
Commissioner O'Brien.
Yes.
Thank you.
And now on to the minutes of August 23rd commission meeting. Is there a motion to approve or amend the minutes?
so moved.
Wait, I'm sorry, who was that? Was that Commissioner
Approved.
David? Yeah,
Yes, Ed David,
thank you.
Second.
move to accept.
So all those in favor, sorry, not all those, commissioners in favor of adopting the August 23rd minutes as drafted, Commissioner Whitworth,
Yes.
Commissioner Ashby,
Yes.
Commissioner David,
Yes,
Commissioner Dusan,
Yes.
Commissioner O'Brien.
Yes.
Oh, your box just moved. Thank you.
And now Amy, the director's report, please.
Yes, good morning, commissioners, and I can't tell you how lovely it is to see all 5 of you here. It's wonderful. So for the director's report, first for administration, you don't have a memo from me because there is nothing new to report, which is always a delight. We do have 2 staffers out on parental leave right now because there's a bit of a baby boom going around, and I hear it's not just us, but so we're a little short-staffed at the moment. For compliance, you have a memo from me stating the status of reasonable grounds cases. And there are 5 that are currently in process. And since the last meeting, 9 that were unsuccessful and 1 that was successful. And the one that was successful, I would ask the commissioners vote to approve the conciliation agreement in EDPA 190435. You have a memo from me about Dion versus YMCA of Southern Maine. So at this time, I would ask if a commissioner would make a motion to approve that.
yes, I'll move to approve the conciliation agreement in, is it EDPA 190435 Dion versus YMCA?
Yes,
Second?
it's been moved and seconded. Is there any discussion? Seeing none. If you're in favor, say yes. Commissioner Whitworth,
Yes.
Commissioner Ashby,
Yes.
Commissioner David,
Yes,
Commissioner, oh, now you moved, Commissioner Dusan,
yes,
Commissioner O'Brien.
Yes.
Thank you. Okay, next, for investigation. In the month of August, we received 54 new charges. It appears as though I forgot to calculate how many administrative dismissals there were, so I'm gonna have to get you that number. We did have predetermination settlements, 14 of them with benefits of about $213,000 to complainants. So, yeah, for litigation, I would ask that we take that after executive session, which would bring us to new business. And there's not much. One item that is important to ask you to do is you have a memo from me about, I think I have it here, but maybe I don't. Oh, I do. A request to withdraw complaints, 2 cases that are on today's, that are tabled for today. And it was okay to do this later on. Normally I have you look at these in the beginning because they're on a hearing, a consent agenda. And if the motion is granted, it would change the agenda. But because these cases are tabled, it doesn't change the agenda. So we have a request to withdraw in 2 housing cases. And in the memo, I gave you the reasons why. I typically do not recommend that we grant such requests after we've issued an investigator's report. In these 2 cases, I do recommend that we grant the requests. And I'm happy to answer any questions, but what I'm essentially looking for is a motion to approve the dismissal, the withdrawal of these 2 complaints.
So moved.
Second.
second,
So it's been moved and seconded, or is there any discussion? Seeing none. Commissioner Whitworth,
yes,
Commissioner Ashby,
Yes.
Commissioner David,
yes,
got to see your hand. Thank you. Commissioner Dusan,
yes,
Commissioner O'Brien.
Yes.
Thank you. The only other new business is I think you all recall that we sent around a memo or press release or memo or both about the changes in the Maine Human Rights Act that will be going into effect. They will be going into effect between now and our next meeting. So I just wanted to bring it up. It's October 18th, and it's going to be an exciting time. Also, I think Barbara's thinking I may be over exaggerating the word exciting, but it is exciting. The legislature's short session, so it's a 2-year legislature, and the short session typically only for emergency acts will be going. The deadline to submit bills for the legislature to consider anything that wasn't carried over from the prior session. That deadline is September 24th, so that would be Thursday or Friday. We only have 1 bill in mind to be submitting, and that deals with a Whistleblower Protection Act decision a court decision that would essentially deprive our agency of jurisdiction over almost any cases that deal with whistleblower cases that touch on or related to union matters. So I've probably described that over broadly. Barbara is trying not to correct me, and I appreciate that, Barbara. But it will be a narrowly structured bill to deal with that one issue. There is a bill of the commissions that actually it wasn't our bill. It was a bill of Rachel Talbot Ross's that was carried over that deals with the definition of public entity in the Maine Human Rights Act. So that bill will be heard as well. Finally, our agency is required to report to all state agencies are required to report to the legislature, to their committees of jurisdiction every few years as part of the overall State Government Evaluation Act. And somehow, I've been here almost 10 years and we've never had to submit one. There was one submitted just before I got here, and the committee, the Judiciary Committee, continued ours, I think twice. But now we cannot escape it any longer, and our report will be due November 1st, and they are very lengthy reports essentially are focused on, is the state agency still accomplishing its purpose? Is it still needed? What laws does it enforce? Are there any federal issues? Are we overwhelmed? Are we underwhelmed? So it's a pretty comprehensive look at state agencies. And so before I see you again, we will be submitting our report. So good times. That's all the new business that I have. Unless commissioners have something they want to talk about, we would have a few minutes before our first morning hearing agenda. Commissioner Dusan.
I'm hoping, will we get a FYI copy of that report? I'd be interested in reading it.
Absolutely, yes. Well, then I guess we have 2 or 3 minutes. Oh, Commissioner Whitworth, yes.
I'll be recusing myself from the first session of the afternoon, H21-0128. I'm sorry, 0126.
Hold on. Oh, right. Yep, I have that. Yep. Thank you.
Okay.
Commissioner David, did you have something?
Yes, would you just review the highlights of the amended jurisdiction that goes into effect? I know I read it once, but this is a teachable moment. I'll try to absorb it.
I was not prepared for that. And Barbara, you're going to have to help me. So there's a few key points. One of them is that the definition of familial status, as it applies as protected classes, typically has been only if you have minor children. It's been expanded to include if you have a dependent adult living with you as well. And now the scope of that jurisdiction has been broadened to cover not just housing, which is where it's usually been, but also employment.
Oh, that's right. Yeah, okay.
Age has been added as a protected class in public accommodations. The word gender identity is included everywhere that sexual orientation is. It's not a new protected class. Gender identity has been covered for 15 years. But now in the statute, it will say, everywhere it says sexual orientation, it will say or gender identity or and. I don't remember if it's or and.
Okay.
I'm sure there's something else. Barbara, what am I forgetting?
Isn't there something relative to convictions?
Domestic violence, actually.
Oh, sorry.
There were changes in what questions you can ask to employees and some other, not under the Maine Human Rights Act. There was something, I think, in the labor statute, but there was another added, it's kind of a protected class, kind of like whistleblower protection, where it's essentially, if you assert a right in some other domain, you can't be retaliated against it in employment because of under the Maine Human Rights Act. So similar to that, there's a protection for victims of domestic violence who have received a permanent order of protection. So it's a very tailored, very narrowly defined protected class, and it's for employment and housing. And we did update our education statute, which is really, it was just out of date, and all the protected classes elsewhere hadn't been carried into education the way they should have been. But that is important, that it be very clear what's protected in education. What else, Barbara? Did I forget something else? All right. And with that, we have 0 time for relaxing.
So back to our meeting. Cases will be called in order on the accepted agenda. As I call each case, the party who has submitted a written argument will be called to the podium to provide the most relevant arguments to the case. The time is limited to 10 minutes. Time may be reserved to rebut opposing arguments, but the time limit of 10 minutes may not be exceeded. Procedural rules of the commission specify that your arguments may address only 1, relevant factual errors, 2, relevant omissions from the report of facts submitted during the investigation, or 3, relevant issues and questions concerning interpretation of the law. The commission allows parties who do not disagree with the investigator's report to rebut comments made by the opposite party. Please be advised that commissioners may ask questions. You'll be asked to introduce yourself as you, as it is your turn. So thank you.
And before folks start, this is a reminder for everybody that you cannot use the names of third parties or witnesses. When we sent you the investigator's report, we gave that, if there was a third party or a witness, we gave them another term to refer to them by, like neighbor or landlord. So please use that descriptor. Thank you.
Okay, so our first case this morning, H20-0085A. It's a reasonable grounds case. Robin Janelle v. Norma Dupree and Eileen Williams. Is there anybody here for the respondent?
They are here. Yes, so, okay, I'm asking you to unmute Miss Dupree.
Okay.
Okay, so hold on before you start. So remember, you can't use the names of any third parties. So basically only Miss Janelle's name, no other, and your sister, but other than that, no other names. Okay. And none of the
Okay.
information that was redacted from your submission. Okay.
Okay. Okay.
So you have 10 minutes and then we will turn to Miss Janelle. Okay.
Okay, so you want me to talk? Oh, okay. Okay, so honestly, I really have nothing to say because it's hard to defend yourself when you can't prove yourself innocent. I've never, ever done anything that Robin is stating I did do. I have no problem with her religion, with her. I live in this backyard. She can't even see my porch when I'm outside, but always found a reason to be on my porch. Like I said in court, I just want this over with because I've never done this. I would never, ever, ever in my life. My brother is mentally challenged and I work for all these companies and I would never do anything to harm anybody or insult anybody that's mentally challenged or has any disabilities. And about the marijuana issue, it was between me and my doctor on that because I've been for the past 15 years taking 2 Ambien a night, which is a lot. So we decided to get me off of Ambien. I would smoke marijuana, which I don't even like. I can't even do that. I don't know how people do that during the day. So I was taking like 2 hits of a pipe. That's all I was taking at nighttime to put me to sleep, which it did. And I was doing that in the house until housing got involved with this. And then I spoke to someone from housing and she told me that I could not smoke in the house because that's still a federal problem. So I said, okay, well, if the landlord gives me permission to smoke outside, is that okay? And I was told, yes, if your landlord agrees, you can smoke outside. And when I smoke, it's usually anywhere from 9 to 11 p.m. So no one's even out there anyway. But I do not smoke at all in this house, at all. I even quit smoking cigarettes. But so I don't know really how to defend myself because there's just no way of proving, like I can't say her bathroom wasn't filled up because I can't with smoke. It really wasn't for me. If you guys would like, I'll bring the video over to the cupboard that she's talking about and show you under the sink. Okay, because it's a small wall and there's no way that, I mean, even if I don't understand how she's saying that, there's no way it came from me if there was smoke in her bathroom because I do not do that. So I don't know what else to say because there's really nothing I can defend myself with.
So if you'd like, you can turn to Miss Williams wants to present anything.
Yes, hi. How are you today? I'm just gonna let you know that I really don't know much about Robin. I kind of was hoping that we could become friends, honestly, but I didn't know her enough. And then we talked very little. Like she would come over on the porch to have coffee with my sister when she seen us. And we did bring up marijuana. I let her know I smoked when I heard about her disability. She told me I had no problem we smoking at all, girl. Only can you do me one favor? I said, yeah, hon, what's that? She says, when you see me, can you poke it out? I said, of course I poke it out. Oh, you're a sweetheart.
Yeah.
I said,
Miss
no problem.
Dupree, I'm
Yeah.
sorry, Ms. Williams, that is not in the record. That conversation that you're just
I'm just
describing.
saying yeah, okay.
Just like Ms. Dupree, when you were describing your conversation with housing, that was not in the record. It's difficult. I don't want to interrupt you, but
Yeah,
it's difficult on
No,
Zoom, but
didn't
you
have
can only discuss things that the investigator was already told.
Okay, well, I know for sure, I do not smoke cig nor weed in my apartment. I have everything brand new. My husband has passed. Everything is brand new. I would not want no smoke whatsoever now. I smoke on the porch. I smoke in the backyard. I here and there do sneak on my walk with my dog. I won't say I won't if I get a chance because you can't smoke in the building. As far as discrimination, no, never ever would I or did I talk to Robin with any disrespect. And I would not. And I don't know much more to say myself because I really am innocent. I don't know nothing. I don't know much about her. I moved in here like 2019, September, and we didn't get to really associate too much because then big fights broke out. Then landlord wanted us to be separated, like not to talk to each other. So I really don't know much, and I just keep getting thrown into this. That's all I know. It's sad but true. It's like, and I feel bad for all this. I wish it never happened. None of this. Like, I don't know what to say because I wish we all could have just became friends. I really don't say to you, except that I definitely did not smoke in the building, did not smoke near her, and did not insult her in any which way or disrespect her. That's all I can say, really.
Okay. Well, thank you. So that was, you'll have about 5 more minutes after we hear from Ms. Janelle. But first, I'm going to ask our commissioners if any of them have questions for Ms. Dupre. And again, I'm sorry, I'm going to say your name wrong every time. And Ms. Williams. Commissioners, any questions for Ms. Dupre and or Ms. Williams? Commissioner Whitworth?
No questions.
Commissioner Ashby?
No questions at this time. Thank you.
Commissioner David? Commissioner Dusan?
I have no questions.
Commissioner O'Brien?
No, thanks.
Okay, so then we're going to turn to Ms. Janelle. So Ms. Dupre, I'm going to keep you muted for now. All right, so let's go to Ms. Janelle, and I know Joan is there to assist you
Can
with.
you hear me?
Yes, we can.
Just checking.
Yep, okay, it's your turn, Ms. Janelle. You have 10 minutes, and I know you've asked that I give you reminders every couple of minutes. Is that correct?
Yeah, I still can't see anything, so seeing a clock is kind of hard for me.
Sure, I figured as much. Yep.
Thank you.
Okay, go ahead.
I had given a police report where Norma had harassed me. I was the one not trying to cause trouble because I know it could hurt her housing. I told the officer, just tell her to leave me alone. I gave you a copy of that police report. That was back in October of 2019. It was the one from Officer Witten, the one that I had put in.
That's the name that I would like you. So as a
sorry.
reminder, Ms. Janelle, right?
I'm sorry.
It's okay. I'm just going to remind you, like I remind everybody else,
Yeah.
not to use the names of any third parties.
So I'll just say the PD.
Exactly.
The one that I gave in from the PD.
Yep.
And, that's when I had put, and I had already said with the other part of this case, that was when I actually put my medical document on the door. So neighbors knew I was allergic to marijuana. I gave a flash report from the ambulance in April of 2019. Eileen Williams wasn't living there. The only one that was at that time in April was Norma Dupree, the people under number 5 and the ones in 2. 5 and 2 didn't smoke weed. She did. Eileen Williams wasn't even living there then. And then she made a statement that supposedly someone moved into apartment 5. Well, the only 2 people in the building at the time besides me, because apartment 6, even though he rents, it's never there, which I did tell that to the investigators. And so the only ones left was Norma and Eileen. The only ones in the building when my workers did those reports, the female and the male worker, they were the only ones in the building besides me. There were other tenants living there, and like I said, in number 6, but he's gone all the time with, friends, stuff like that. So there's no way with my workers coming in, ambulances coming in because of my problems, that they weren't smoking it in the building. Because it was smelled in the hallway by a city worker with the ambulance. There's no way. And Eileen wasn't even there then. So that leaves it to Norma. I mean, I thought we were friends. It only takes a moment to make a friend. It takes a lifetime to keep one. That's what I said during the investigation. They say we weren't friends. Well, how do you make a friend? It only takes a moment. And I tried to do everything, including not putting an order on her by the PD. I was still trying to make things work, even though I was scared for my life, scared to sleep in my own home. Begging. But they just want to do what they want, when they want, where they want, just like I had said before. And I did get some repercussions about putting crepe paper over my door for Hanukkah. I got snide comments from Norma. But I've suffered a lot. And there was no need of it. Because under Maine law, she has to have explicit permission from the landlord to have any type of product. It's got to be spelled out according to Maine law, what he allows on the property.
So that's about 6.5 minutes, just so you know.
Okay, and he's never given anyone the explicit permission the law requires. So they shouldn't have had it on the property at all. I've given you the court document of first Norma saying she didn't do it, but then within the same sentence, she did. Contradicting herself within 10 seconds on the stand in court. And that's all.
Okay. Commissioners, any questions for Miss Janelle? Commissioner Whitworth?
No questions.
Commissioner Ashby?
None, thank you.
Commissioner David?
No.
Commissioner Dusan? Commissioner O'Brien?
No, thanks.
Okay, so at this point, so both, Ms. Janelle, you'll have just over 5 minutes left after we go back to Ms. Williams and Ms. Dupre, who I'm just trying to find them. Everybody keeps moving. Okay, there you are. So at this point, I'm going to unmute you, Ms. Dupre, and you don't have to say anything more. You have just over 5 minutes if you want to say something else. So if you want to, you have that time now.
Okay, I just want to say that I don't do what this is saying. I never ever made any comment about crepe paper. I don't even know what she's talking about. I don't even open my entry door at all to see her door or anything. I just wanted this to end, and the harassment order she won because I didn't go to court because I have a forgetful mind. I didn't do any of what she's talking about, and I think it's awful that I can't prove. I don't know how to prove my point of it besides going on Dr. Phil. And that's why I didn't want to sign the disclosure form, because I was trying to work to get a lie detector test and a hand analysis test to prove for once and for all that I'm being accused of things I'm not doing. I've been begging everybody for a loan so I can get this done with. But it's the only way I know how to prove that part. Anyway, give me a lie detector test, and you'll see I'm not lying. I don't do these things. I would never do anything she said. And about the night the ambulance even came, I said to him, can I go to bed? I'm on Ambien. And he was like, you took Ambien? I'm like, yeah. He goes, go to bed. I wasn't even smoking. So I have that night, I don't know what she's talking about with all this. Sam, I don't know what I can say and can't say, but I know that windows were open constantly and the people on all four sides of our building smoked. Every single person around here smokes. And the landlord was outside one day and my sister made a joke because the marijuana they were smelling. My sister said, hey, Norma must be up there smoking because can't you smell it? It's everywhere. It is everywhere around here. Every single house on the side of us smokes. And the windows are open, entry is open. No one used the entry besides her friends. That's it. No one else uses that entry besides her friends. So whatever goes on in that entry, I don't even know. I have it blocked off like I've had for a long time. I even made a cop go to the front door because I don't open the door. So I don't know. I just didn't do none of this. And I don't know honestly how to prove. I wish I did have the intelligence to know what to do. Besides Dr. Phil.
Miss Williams, do you have anything you want to add?
No, except God bless everybody. I don't really know what to say. I'm just saddened by this all, that's all. I really don't know what to say, except I don't really do any of what I guess I'm being accused of too, of smoking weed or whatever. Yes, I do on a porch. Yes, I do on short walks. Yes, I do in the backyard, which I don't know if Rodney never knew, but I was at the cellar door. I mean, but that was basically it. I don't have nothing else to add, and just God bless her.
Okay, thank you. Questions, commissioners, any questions for Ms. Dupre or Ms. Williams? Commissioner Whitworth,
No questions.
Commissioner Ashby,
No questions.
Commissioner David,
No,
Commissioner Duson,
No questions.
Commissioner O'Brien.
No, thanks.
Okay, so I'm going to mute you now, Ms. Dupre and Ms. Williams, because we won't hear from you anymore at this point. So you can stay on and keep, we're not done with this case, but just from the part where you get to say something. So Ms. Janelle, you have about 5.5 minutes. If you want to use them, you don't have to, but you can. You do. Okay, go ahead. And I will do a better job of reminding you when after a couple minutes.
Right in the court document, because I had gotten a transcript of the hearing. All right, Eileen Williams admitted to being a heavy marijuana smoker, her own testimony in the court. The transcript that I provided of that hearing before the deadline. Norma even admitted to going downstairs and smoking it with her sister. All right. Eileen, in her testimony, even said she was going over regularly before she was living there to visit and be with her sister. They were smoking it in the apartment. Okay, there's no other way it could have gotten in. Because with my window shut, how would it get to a bathroom with no window and only a vent fan over a stall shower? And that's what I told the investigator. I believe I even gave her a picture of my bathroom and under the sink, where I was begging the landlord to turn around and, at my cost, block it. And when I left, I wish I could have given you a picture, but I only had to December to get stuff in, or I would have given you a recent picture that things hadn't been fixed. I mean, I tried to do things at my own cost, and I constantly tried to work things out, but it was easier to get rid of me than to get rid of someone that would blow the whistle that there's marijuana on a property under a HUD contract. Because at the bottom of the family obligations that you receive, it's not allowed. Even if you got a medical card, it's not allowed. Right on the housing document, the family obligation one. I thought I was moving to a safe place, and I figured where Norma even testified she was on housing, she'd know better and should warn her own sister.
So you have about 3 minutes left.
That's all I've got to say.
Okay,
Because I
thank you.
don't know if Eileen is on housing or not, but I know Norma is from her own testimony. That's all, sorry.
Okay. Commissioner questions for Miss Janelle. Commissioner Whitworth,
No questions.
Commissioner Ashby,
No questions, thank you.
Commissioner David,
No,
Commissioner Dusan,
I have no questions.
Commissioner O'Brien.
All set, thank you.
Okay, so that's it from the parties. So I'm going to mute you, Miss Janelle. Oh, next, we're going to go to the investigator, Alice Neal.
Good morning, Commissioners. I am Alice Neal. I was the investigator on this case. You've heard from the parties today about the fact that there were issues with smoking in and around the building related to Ms. Janelle and interfering with her housing and being able to use and enjoy it fully because of her medical allergy to marijuana. And we've heard the respondents say that they either smoked on the porch or indoors. And I have read and saw the testimony in the transcript from the protection from harassment hearing between Ms. Dupree and Ms. Janelle from July of 2020. And both of the respondents admitted that they smoked marijuana, which they knew at the time was affecting Ms. Janelle, and they continued to do so. And it was based on those facts and the information that I reviewed that I found that I recommended a finding that there are reasonable grounds to believe that Ms. Dupree and Ms. Williams interfered with Ms. Janelle's housing. And I haven't heard anything today that changes that recommendation, but I'm happy to answer any questions that you may have.
Thank you, Alice. So Commissioner questions for Ms. Neal. And again, just as a reminder, Commissioners, I know you have the entire report in front of you, the investigator's report. All of the issues and all of the recommendations in this report were already voted on, except for number 3, which relates to Ms. Dupree and Ms. Williams. So that's the only finding at issue in this hearing today. So with that in mind, any questions by commissioners for the investigator? Commissioner Whitworth?
No questions, thank you.
Commissioner Ashby?
None, thank you.
Commissioner David? You're muted.
Amy, you need to bring me up to speed about how those other things got voted on. Was that last meeting or
Oh,
something?
that's right. You weren't here at last meeting. Okay.
I was not here.
Yes. So at that time, the number 1, the reasonable grounds recommendation against the property owner, landlord, May and Dennis Simmons, that was a reasonable grounds finding, number 1. And number 2, recommended reasonable grounds finding regarding the Simmons's retaliation against Ms. Janelle. That was also a reasonable grounds finding. No.
Okay, they were landlords.
I'm sorry, Alice is shaking her head. I am incorrect. It was not a reasonable grounds finding. Thank you, Alice. And numbers 4 and 5, those were all no reasonable grounds findings.
Why didn't 3 get disposed of?
There was a notice issue that regarding Ms. Dupree and Ms. Williams, and it was so hard to get this case, I don't know if you, we initially sent out the investigator's report in May, and it has taken us all this time because of the complications of having all the pleadings dictated so that they could be accessed. So Ms. Janelle had full access to the process. It took quite some time to be able to get everything dictated and available. And by the time we did all that, everything was prepared for hearing when we learned from Ms. Dupree and Ms. Williams that they were not aware of the report and reasonable ground recommendation against them. And so we needed to table that one recommended finding so that we were sure that they had notice and an opportunity to respond.
Okay, thank you. Alice, on page 11, just before the recommendations, you say that Dupree stated that she would smoke whenever, wherever, and how much she wanted. And you continue to stand by that, correct, in the face of her denials?
I do.
All right. Thank you. And maybe I'm going down a rat hole, but a question for Barbara. Is the legality of use of marijuana implicated here at all, or the ins and outs of federal housing as opposed to state law, or can we ignore that? Those
You
kinds
can
of
ignore
questions?
that for this part of the case.
Okay, thank you. That's all.
Thank you, Commissioner David. Other questions for the investigator? Commissioner Dusan,
I have no questions.
Commissioner O'Brien? Okay, so thank you, Alice. Great job on a very complicated case. So then at this time, there is only one proposed finding for commissioners to address. And that is number 3 in the investigator's report on page 12.
I'll move that we find that there are reasonable grounds to believe that the respondents, Duque and Williams, interfered with complainants' rights under the Human Rights Act, and that that portion of the complaint should be conciliated in accordance with the act.
I'll second that.
Was that Commissioner David or Commissioner Dusan?
It was actually both of us. I'll defer to Commissioner David.
Okay, thank you. So it's been moved and seconded to find reasonable grounds to believe that Ms. Dupree and Ms. Williams did interfere with Ms. Janelle's rights under the Maine Human Rights Act. Is there any discussion among commissioners? Seeing none. Okay, so a vote yes means you agree with the reasonable grounds finding against Ms. Dupree and Ms. Williams. Commissioner Whitworth,
Yes.
Commissioner Ashby,
Yes.
Commissioner David,
Yes.
Commissioner Dusan,
Yes.
Commissioner O'Brien.
No.
So the finding is reasonable grounds to believe that Ms. Dupree and Ms. Williams interfered with Ms. Janelle's rights. Just so the parties know, our agency will be sending you a letter about the next steps in this process after a reasonable grounds finding. So, and Ms. Janelle, I will be calling you to talk about the essentially the equivalent of a letter telling you the next step in this process. All of you are welcome to stay in the hearing, but that your case is finished. And we thank you for participating. So that brings us to the next case. Commissioner Whitworth, you got it. Oh, you're muted. You're muted.
Sorry. Public accommodation, PA 19-0376. Nanendra Jayarjan, pardon my pronunciation, the State of Maine, York County District Court. Is there anybody here for the complainant?
Can you unmute? There you go. Now it says on your screen, Angelo Jayarajan, and I'm sure I've also mangled your name, for which I'm very sorry. Is it Angelo or is it Ganendra?
Well, it's Angelo Jnanendra Jayarajan.
Okay. Okay.
You're welcome to call me Angelo if you like.
Thank you so much. And you are welcome to call me Amy if you like. Okay. So then Angelo, you have 10 minutes. And again, just don't use the names of any third parties or witnesses.
Okay. So my complaint is very simple. When I say simple, in the sense, I felt my opposition is American white, and you could hear my accent and my color. So when I, through the years in Maine, going through a family hearing, family divorce, I was accused of a lot of things, but none of them were proved. And the opposition party's counsel filed many false allegations, and the state of Maine did not take any action. but the Board of Overseers did in May of 2017 and filed the opposition party filing false allegations were true. Since then, I've been in court a couple of more times where I provided the court with my child support documents. Although I provided all those documents, none of them were encountered, and my child support increased by 65% when my salary never went up, and the opposition's party salary went up by 20%, and no custodial time was changed. When I asked for an explanation, all I hear was other person was credible, but the main court says you need to add all those information, but the judge denied it. I appealed it, that was denied. Without, all I got was the other opposition party was more credible. So they basically violated the main rules. The second child credit was never given to me, although they were provided with all the information. I'm just going through my list, sorry.
Okay.
And since then, I have filed in 2020, June, I filed to change the custody of my daughter. That custody hearing has not been heard yet. Now we are in 9/20/2021. I filed for child care modification in 2019 September, not been heard yet. So since I filed this case, everything that I file is just put on the back burner. And I understand it was COVID, but COVID is now gone. And the funny thing is, if the plaintiff, the opposition side, asked for financial records, that hearing was done right away. So I don't know. I don't see the reasons why is that my hearings are not heard and the opposition's party's hearings are heard right away. When I ask, they say, well, that's up to the judge. So at the end of the day is my child support increased by 65%. Nobody could give me a reasons why. None of my income was changed. All I hear is that the opposition party is credible. There's nothing to do with credibility here because it's a law. The law says if you go through a calculation and they have the right to change it, but the judge at the end of the day can say he's not changing anything. So here I am paying 65% more since 2017 for a second child that I have, and none of my income has changed. And there are other things, as happened in the court that I'm not going to start with that, but I'm sure you guys have read it. So if you have any questions, go ahead, ask me.
Thank you. Hold on one second. Okay, so I'm going to see if commissioners have any questions for you. Commissioner questions for Angelo, Commissioner Whitworth.
No questions, thank you.
Commissioner Ashby,
None, thank you.
Commissioner David,
No,
Commissioner Dusan,
I don't have questions for the complainant.
Commissioner O'Brien.
No, thanks.
Okay, so you'll have about 4 minutes left after we hear from the respondent. I'm going to mute you for now. And I believe Ms. Morrell, is that you?
Yes, thank you.
Okay. Yep.
Morning, Commissioners. My name is Kelly Morrell, and I represent the York District Court. As you heard, the basis for the complainant's charge in this case is that he is unhappy with the judicial decisions made in his post-divorce proceedings. The proper forum is with the court, and I believe he did take advantage of the appeal process with the court in this case. The investigator here correctly determined that most of the complainant's allegations in his charge were beyond the 300-day statute of limitations, so they were untimely. Most of his allegations were against the York District Court, and all of those allegations were untimely. To the extent the law court is a respondent in this case, I believe he did file an appeal in 2019, and the last action by the law court was May 2nd, 2019. So that probably would be within the statute of limitations. He hasn't presented any allegations or evidence of discrimination by the law court with respect to the denial of his appeal. So the commission should adopt the recommended finding of the investigator here that there are no reasonable grounds to conclude that any discrimination occurred against him and dismiss the complaint. I'm happy to answer any questions.
Thank you. Hold on. Okay. Commissioner questions for Ms. Morrell. Commissioner Whitworth,
No questions. Thank you.
Commissioner Ashby,
None. Thank you, Attorney Morrell.
Commissioner David.
Attorney Morrell, I'm puzzled by the jurisdiction here to be hearing this at all. Why, how does, I mean, family lawyer that I was, I don't understand how you can attack the district court process, the fact finders, the appellate process with an allegation in another forum.
I think you're correct, Commissioner David. We did make an argument during the investigation that there was a separation of powers issue here and that the commission doesn't have jurisdiction to review a decision of the court, of the judicial branch. So I do think that's an issue. There's a jurisdictional issue here.
All right, I'm gonna ask our counsel that when we get to her. Thank you.
Okay. Commissioner Dusan, questions for Ms. Morrell?
No, I think my questions are for our counsel. Thank you.
Commissioner O'Brien.
No, thanks.
Okay. Angelo, you have about 4 minutes left if you want to use them. You don't have to, but you're welcome to. Oh, you're muted. There you go.
So the 365 days is only for one, not all of them. So let's make sure this is what the court does. They give all kinds of excuses for not doing their job. The reason I came here because I can't think of anything else. The main law says this, but I can't think of anything else because of my different color to my ex-wife, who is an O'Brien, Irish. So I can't, that's the only reason I'm here. But as everything in the United States, until somebody gets cut into pieces or something happens, nobody cares about it. So I understand your point of view. Yes, I did appeal it, but all those appeals were denied without any basis of any laws were provided. So the court has the right, I have the right to get the decisions why they were denied. But nobody, the judge never gave a reasons why. And nobody in this world should be above the law. They're supposed to follow the law. And that's the reason I came to you guys, to see at least they have 1% of a chance to file this evidence. But as Edward David pointed out, why is this, is the court above human rights? If that's the case, then we should not be here. So if you're a family lawyer, then probably you should know better that we are discriminated because who we are, not what we provide. And that's what I'm here for. So it's not the money, it's about the status. We come to this country for a better life, but if you guys are, if the state of Maine are against colored people because we all provide the details and all the evidence were provided and all I get is a denial, is that the judicial way of dealing with the law? The laws are not done, that's why I came to Maine. Human rights. Hopefully they will do something, but apparently that's not the way it works. Thank you.
Commissioners, any follow-up questions for Angelo? Commissioner Whitworth?
No questions.
Commissioner Ashby?
No, thank you.
Commissioner David?
No.
Commissioner Dusan?
No.
Commissioner O'Brien?
No.
Attorney Morrell, any follow-up from you? You have about 8 minutes left if you want to use them.
Oh, thank you.
Okay. So then at this point, we would turn to the investigator, Ms. O'Reilly.
Morning, Commissioners. My name is Jane O'Reilly. I was the investigator on this case. And Commissioner David, I'll try to answer your question regarding jurisdiction. As I sort of explained the focus of my investigation, the Maine Human Rights Act would look at whether or not the court in its actions was acting in a discriminatory manner. So the allegations made by complainant were that while he was going through his court process, his treatment was biased based on his race, ethnicity, national origin. But as was pointed out by respondent counsel, all of his claims were untimely in this manner based on the fact that he named a court whose most recent actions were in 2019. So that's where I made the findings in my investigation. I did note that even if the correct law court actions had been named, which were the most recent actions, that there was no evidence in the record that those actions were biased in any way.
Right.
Thank you, Jane. Commissioner questions for the investigator, Commissioner Whitworth,
No questions. Thank you, Jane.
Commissioner Ashby,
No questions, thank you.
Commissioner David, anything else?
I guess not. It just seems to me that it would be dismissed administratively, but on jurisdiction. But I hear you saying that we have a jurisdiction to still second guess the court on that. But
Yeah, it's not second guessing the court. It is a question of whether the court might have subjected anyone. The courts are still answerable to our agency in terms of discriminatory treatment, not any particular decision that they make.
Yeah, no one is suggesting that we would be able to overturn the court's decision, but a court is a place of public accommodation and therefore is covered. If the court's actions are discriminatory, it would be an entirely separate cause of action.
Yeah.
okay. It's the first one I've seen in the commission in a year and a half.
We've got plenty of them. Follow-up questions for Angelo. Any additional questions, Commissioner David, for Angelo?
No.
Okay. Commissioner Duson?
Yes, I have a couple of questions.
I'm sorry, it was for the investigator. Sorry, I am
Yes,
a
I
little
understand.
befuzzled. Thank you.
Thank you. As to the issue of jurisdiction, if a party in a court proceeding thinks that the court is biased based on one of the protected class issues, is there any other forum other than the Maine Human Rights Commission that I could come to have such behavior reviewed?
I think that question is outside the scope of what I would know as an investigator.
Okay. But your determination, I assume in consultation with Corporation Counsel, was that the case was appropriately, it was okay for the case to be filed at the Maine Human Rights Commission.
Correct.
Okay.
And as Barbara mentioned, it wouldn't be to overturn or to change any of the decisions.
Of course not. It's on the matter of discrimination or bias. On the allegations about bias are directly in the complainant's documents, are directly related to statements that he alleges were made by respondents' counsel in the court proceeding. And so I just want to make sure I have straight in my head that the finding that the filings were untimely were procedurally sufficient for you to move forward, for us to move, for the investigator to move forward to the report status without going. So if you hadn't found that it was untimely, then you might have gone to transcripts from those proceedings to see if those statements actually happened. But since it was not timely filed, you would not have gone into more detail around what was said or not said by the hearing officer at the actual hearing that he was complaining about. Am I understanding that correctly?
I would have to look at all of the decisions that were made within the 300-day period. So if he had made a filing directly after that trial back in 2017, I would have looked at those actions.
Okay, that was my understanding. I just wanted to make sure that that was the step through process. So jurisdiction, bias, what forum, timeliness. Thanks. I am all good, and thank you very much for a very detailed report.
Commissioner O'Brien, any questions for the investigator?
No, thanks.
Okay. Okay, then. Thank you, Jane. At this point, we would have, we've heard from the parties and from the investigators. So at this point, we would need a motion. There is one recommended finding here. But it does clump a bunch of things together, protected classes. So if any commissioner wants to separate those out, please feel free.
I'll move that there are no reasonable we find that no reasonable grounds to believe that the respondent discriminated against the complainant on the basis of race, color, national origin, and or sex, and that the complaint be dismissed in accordance with the act.
Second.
That's been moved and seconded. Is there any discussion among commissioners?
I'll just very briefly, I think I heard Commissioner Duson ask a question about whether or not the statements that were allegedly discriminatory were attributable to respondents' counsel, and that's not the case. I think am I correct to understand that the allegedly discriminatory comments were made by the complainant's wife's counsel in the course of the divorce? I just want to clarify that I don't think that there's any allegation that respondent made on any record any discriminatory statements.
So this is a discussion period, not a necessarily a question. Was that a question for the investigator, Commissioner?
I just wanted to point out that's my observation. That's all.
Okay. Is there any further discussion among commissioners?
Yeah, I also in response to Commissioner Dusant's query as to where else there could be complaint filed, it would be in the judicial review process and the Council on Judicial Ethics, if there was a claim that the court was discriminating in some way. And the fact that counsel may have crossed the line, and I have no reason to question complainant's assertion that counsel was disciplined, but that's a freestanding thing that doesn't implicate the court in any discriminatory procedures. That's all.
Any additional discussion from commissioners? Commissioner Duson?
Well, I'm not going to use up a lot of time going back and forth on this, but on the 2 points mentioned, one is that in response to my question, the investigator confirmed that the commission staff made a determination that this complaint was appropriately before the commission, that this complaint is an allegation of discriminatory behavior based on bias as to a protected class that the complainant belongs to. And so I'm just wanting to make sure that as we create a record for this matter, that whatever disagreement there might be amongst the commissioners as to whether the matter is appropriately before the commission, there's been a determination that it is appropriately before the commission. And so I just don't want the complainant to walk away, or those who might be following commission precedent to walk away thinking that this type of case cannot be brought to the commission. On the second matter, perhaps I misspoke, but it's my understanding that the basis of the concern here is that the complainant feels that the process in the other jurisdiction, that the hearing, that the court was biased, and he provides in his discussion, that the evidence of that the only evidence he provides in his discussion is his allegation that there were statements made by his ex-spouse's counsel that, I'm not going to repeat them, but that called into question, that called his behavior into question or his attitudes into question. I raised that because my understanding is that if he had filed timely, then in order to investigate, the investigator might have had to go to the records from that actual proceeding, but it wasn't filed timely. And so that trumped that early step ended. So you didn't need to go beyond that to go into the case because it was not filed timely. So those issues were not reviewed. I understand why those issues were not reviewed, and I just wanted to make sure my understanding was correct, was accurate.
Commissioner Newsom, that clarifies it for me. I agree with you. It was the ex-wife's counsel. I just thought I heard you say in questioning the investigator, I heard you reference statements made by respondents' counsel. That's all. I just wanted to clarify the record that there was no respondents' counsel involved, in, of course, in the proceedings in court, and no respondents' counsel ever made a discriminatory or allegedly discriminatory statement. That's all.
Absolutely. I misspoke. I can't roll back the tape, but if that's
I may have misheard. That's always possible.
Thank you.
Any additional discussion from commissioners? Okay, so the motion is to find no reasonable grounds to believe that unlawful discrimination occurred based on race, color, national origin, and or sex. So if you say yes, you agree that there are no reasonable grounds. Commissioner Whitworth?
Yes.
Commissioner Ashby?
Yes.
Commissioner David?
Yes.
Commissioner Dusan?
Yes.
Got to see your hand. Thank you.
Now wait, so yes.
Thank you very much. Commissioner O'Brien?
Yes.
Okay, so the vote is 5-0. The finding is that there are no reasonable grounds to believe unlawful discrimination happened. And for the parties in council, the commission will send you a letter describing the finding and next steps in the process should you choose to pursue them. Thank you very much for being here today. You're welcome to stay and listen, but we're moving on to the next case.
And our next case is E19-0400AB, Christina Porter v. CMMC Family Medicine Residency and CMMC. Is there anybody here for the claimant?
Good morning. Yes, my name is Laura Garcia, and I am counsel for the complainant Christina Porter in this matter. And she is also with me this morning.
Okay, you'll have 10 minutes.
Okay. Good morning, commissioners. I am here with my client, Christina Porter, and I appreciate the opportunity to address you this morning in this matter. I'd like my client to say a quick hello, just so that you know
Hi,
she's here.
I'm Christina Porter.
I do want to take this moment to talk about the facts which are agreed upon. In this case, the patient entered the clinic and met the PSR, tried to register, became escalated, became agitated, used sexual and foul language. Ms. Porter turned to her coworker and quietly said, "Do you need assistance?" At which point the patient turned on her and told her to shut the fuck up, mind her fucking business, and turn around. Now, Ms. Porter, at this point, told the patient, "When you speak like that, you are making it my business. You have two options available. You can sit down and patiently wait for your appointment, or you can go to the ER and get assistance if you need it earlier." The patient then escalated even further and told her that she was a fat fucking bitch, a fat fucking cunt, gave her the finger repeatedly, and this lasted for 15 minutes, during which time she warned the patient 3 times calmly and professionally. I would add that her floor supervisor, the lead PSR, was watching and did nothing to offer assistance. Ms. Porter finally called security and the patient was escorted from the building. While being escorted, he continued to taunt her and give her the finger. The upshot in this case is that that was a hostile environment created by a patient that the respondent was fully on notice and has admitted on the record had a history of escalated behavior and inappropriate conduct. Now, there is a policy, an administrative policy that I provided to the commissioners that CMMC has for exactly this kind of situation, because CMMC, in its role as a healthcare provider, is both an employer and also a provider. And it has to navigate situations like this. You cannot just ignore the employee's rights because this is a family residency. So this administrative policy is exactly what Ms. Porter was following. This was inappropriate language as defined in the policy. She warned the patient. She then had the patient removed from the public space. She completed a write-up about what happened. She reported it to her manager. Respondent never produced that write-up, by the way, along with other documentation that was never produced. But basically, the supervisor or office manager did an investigation that, according to her notes, was completed within that day. And she didn't talk with everybody who witnessed the incident. She actually only interviewed 2 people who were the ones that didn't actually fulfill their duties. The PSR, who was tending to the patient and who Mr. Gichos found was not able to de-escalate the patient. And then the lead PSR, who stood behind, frozen in inaction, as Ms. Porter suffered this verbal assault. The worst part is that the office manager didn't follow the policy in terms of giving a written warning to this patient, nor had there been any written warnings given in the past, even though the respondent admits that this behavior was typical. So I ask you, should Ms. Porter have to tolerate this behavior? Should other PSRs have to tolerate this behavior? Should patients who are in there have to tolerate this behavior? Or are we going to allow CMMC to hide behind its own negligence in not earlier addressing known behavior? They didn't provide information or guidance or education to their employees on how to deal with these situations, despite having a policy. The policy is not worth anything if you don't provide that background. Now, they blamed her. I have, during this case, referred to it being very much like a domestic violence case, where the abuser says, "You made me do it." And that's exactly what CMMC told Ms. Porter. This is on you. In fact, Mr. Gichos asked the human resource person, "Hey, did anybody ever say to her, this is on you?" And she said, yes. That's exactly what CMMC said. And they haven't backed off from that position. And they never even told her what their decision was. So she was faced with the patient coming back in, and she wasn't sure what to do. So she turned to the lead PSR and said, "What should I do?" And that lead PSR, who had been told, said, "It's business as usual." And then later told her, "You're just mad he's not being discharged. You should have done what he said." You mean shut the fuck up and turn around? And here's the thing. Ms. Porter was so upset that she went to human resources. Now, the human resources person had already heard about this because the office manager had called her and said, "Did I handle it appropriately?" Mr. Gichos did not explore what human resources told this woman. He didn't even ask if the policy had been applied. He didn't ask if human resources was concerned about that. He didn't ask, did you investigate whether there had ever been any write-ups of this patient before? Instead, everybody just deferred to the doctor and the office manager saying, they say he shouldn't be discharged because he's not violent. The question here is not whether he is violent. And I would say that you can't really say whether he's violent or not. As a matter of fact, a former patient of the clinic had a few months earlier murdered somebody a couple of blocks away. So you can understand why somebody in Ms. Porter's position would be concerned about this behavior and her safety. The safety plan that was put in place, it was not immediate and corrective action as required by the law. It was an effort to appease Ms. Porter. Here's the reality. They said they documented the safety plan. They didn't produce it. They said she could leave the premises when he came in. EEOC guidelines say that when the harasser and the abused individual have to come into contact, the way to handle it is you remove the harasser. You don't remove the individual who's been abused. And the worst part is they didn't even tell her coworkers. And so when he came in, she had to tell them, which just fed into the fact that they had already told all the coworkers it was her fault. And once again, she's not getting over it and moving on. What should be required under the law for immediate and corrective action is a review of the policy, a review of what's required under the law. There is some case law on this that talks to, part of it is how much control you have over the harasser. They had control over the harasser. They could basically say, you're not going to be able to come here to get medical care if you don't stop this. But the reality is they were never enforcing their policy. If they had, guess what? There would have been prior write-ups of him and he would have been discharged. Or at the very least, the policy provides they could have made arrangements for him not to be in a public space or have to interact with other people and eliminate the possibility of another incident. They didn't do that. They just wanted her to accept fault and move on. It's not acceptable. It's against the law. And CMMC was negligent and it shouldn't be tolerated. The way they handled it, they passively tolerated it and had an expectation that she should just be okay with it. I hope you're not okay with it. Thank you. And I'm happy to answer any questions, and Ms. Porter is as well.
Thank you, Ms. Garcia. Just one second. Commissioner questions for complainant's counsel or complainant, though we don't hear witness testimony at this point. Commissioner Whitworth?
Yeah, I do have a question. The record indicates that the patient is a long-term patient with a mental disability who has a known penchant for swearing and escalated behavior. And further on in the report, the investigator writes that the people who were interviewed agreed that the patient was being inappropriate, but that they did not feel threatened by him. They didn't feel that they needed assistance. And they felt that the actions of the complainant may have attributed to escalation of patient's behavior. So I would like to know how you respond to that, please.
How I respond to that is the hostile environment is an environment in which somebody, sexual language, okay? And what I believe I included it in the report to you or my submission. The actual policy defines the inappropriate language to be foul language and swearing. Okay, and during the interview of the human resource person, they admitted that the word fuck was something he used regularly. And that particular morning, he was going on about how he needed an STD test because he'd fucked a skank and da 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 da. It's not about whether those two individuals felt that it was inappropriate. Ms. Porter felt it was inappropriate. And under the law, she shouldn't have to listen to that, nor should anybody in the waiting room have to listen to that. He also was busy berating the clinic. So again, the actual policy of CMMC says inappropriate language includes the behavior that has been described and attributed to him. Additionally, with regard to the claim about his mental disability, if you look at the policy, part of what the policy says, if the individual, it's kind of, there needs to be a distinction made. Can the individual control the behavior or not control the behavior? The policy talks about the fact that there are going to be diagnoses in which the individual cannot necessarily control the behavior. Examples are given: schizophrenia, Tourette's syndrome, dementia, persistent developmental delays. In those cases, what should happen is the person should be removed from the public setting, okay? And a plan should be made so that you can provide patient care. That's about the patient's rights. But we still have to be concerned about the employee's rights, which is why you make a plan to remove them to ensure that the hostile environment does not happen for the employees. Now, if the patient can control their behavior, okay, then we do the written warning routine. Here, what's confusing is CMMC kind of wants it both ways. On one hand, the office manager says she's talked to him and she told him, don't do it again. And that's enough. We don't do a written warning, registered mail, as we're supposed to. We don't give him his patient's rights and responsibilities, a document which says he has a duty to behave appropriately and be polite with staff. And he continued to come in and make comments like, I don't know what her problem is, or that girl out front, she just doesn't like me. And I wouldn't have continued here unless the office manager, I can't say names, hadn't begged me to stay. And then with the safety plan, the staff would say, your boyfriend is coming in. Or they would call her up and say, you can come back upstairs now, your break is over. Because again, the message that was communicated consistently from the office manager was, it's your fault. This is on you. They can't have it both ways. They can't say, don't worry about it, he won't do it again, and then turn around and say, hey, the doctor says he has a mental disability. If he has a mental disability that causes this behavior, they have an obligation to put a plan in place. And to also actually speak with the staff about, this is his issue, this is what we're doing, this is how we want you to deal with it, and here are some tools to do that. None of that happened. As a matter of fact, the only tool that was given is during the meeting on October 24th, when they met and the office manager told the PSRs, this is on you, Tina. The only tool, the office manager said, to de-escalate a patient, you should just tell them, please don't use that language in here. Women and children actually get seen here. That's it. I can tell you right now, had she said that to this particular patient, given his history, do you think that would have worked?
Ms. Garcia, I don't mean to interrupt. This was actually just an answer to a question.
Yep.
And it's gone kind of.
Sorry.
Commissioner Whitworth, did you have any other questions for Ms. Garcia?
No, thank you.
Okay. Commissioner Ashby?
None, thank you.
Commissioner David?
No.
Commissioner Dusan? You're muted. There you go.
There, I was having a little trouble getting my mute button to work. No, I have no questions. Thank you.
Thank you. Commissioner O'Brien?
No, thank you.
Okay, thank you, Ms. Garcia. So now we will turn to Mr. Messerschmidt, I believe.
Good morning, Commissioners. Michael Messerschmidt for the respondents. The family medicine residency prepares family physicians who go on to provide care in their chosen communities. It's part of Central Maine Healthcare. It is effectively a safety net family medical practice with a challenging patient population. The population does include a great many people in the Lewiston area with mental health issues and substance abuse disorders. Patients will come in and raise their voices, and they may become agitated. Part of the job of all staff at FMR is to de-escalate. As of early October of 2018, this patient was a long-term patient of the practice, a known history of mental health struggles. Complainant Porter had been employed at the family medicine residency for nearly 5 years as a PSR, patient services representative. On October 8th, she had an interaction with the patient, as a result of which she called security to have him removed. The practice manager promptly interviewed all individuals involved, including Ms. Porter, two co-workers who witnessed the entire events unfold, as well as the patient. The information provided was in stark contrast to one another. All agreed that the patient had been speaking inappropriately, but the complainant and her co-workers disagreed as to whether her intervention was even necessary and whether it contributed to the escalation of the patient's inappropriate behavior. He had been using vulgarity in a low voice, almost joking, but it was not directed at anyone in particular. They reported that his behavior was escalated when she inserted herself into his conversation with another PSR who hadn't asked her for help. In his interview with the practice manager, the patient himself apologized for his behavior, and he agreed to use appropriate language moving forward. When the practice manager met with the staff involved in the incident to conduct a debriefing and to discuss areas of opportunity with team de-escalation, Ms. Porter became agitated and she asked her two PSR colleagues to leave the room so she could have a private conversation with the practice manager, during which she expressed dismay that her colleagues weren't supporting her. And she said the practice needed to discharge that patient. She acknowledged that she did not usually interact with this patient because she had a history of escalating him. She claimed that because no one else was doing anything to stop his conversation with this other PSR, she decided to intervene. The patient told her to turn back around, it's not her business, all the while using profanity. She did tell him she was going to make it her business and that he could stay and act appropriately or leave and go to the ER. He continued. She had him removed by calling security. A couple of weeks later, she reports that the patient had been back at the practice and had told a nurse that, quote, the girl in the front did not like him. The practice manager had also spoken with the staff to whom Ms. Porter claimed he had said bad things about her. She learned from them that he had in fact been openly remorseful about the earlier incident and that he was being appropriate and not at all bad-mouthing her. She received another call from the patient himself who expressed his concerns about the initial incident in October. The decision to discharge a patient from a medical practice is a medical decision, and the question was referred to the doctor who is the program director and has in fact been this patient's physician for 8 years. She reviewed the situation in the context of his medical needs and the ability of the practice to provide those services in a manner which provided safety for the providers and the staff. She was keenly aware of his long-term history and with his mental health struggles, which, by the way, do not include any history of violence. His behaviors were well known to the practice. She was aware of the conflicting accounts of the events, as well as the patient's expressions of concern and his desire to apologize. She made the medical judgment that while his behavior was abusive and disruptive, he was not threatening or violent. He had a history of profanity, but no history of violence. She determined he remained an appropriate patient at FMR and conveyed that decision to the practice manager, who relayed it to Ms. Porter. 3.5 months later, Ms. Porter tells her practice manager and openly to coworkers that she no longer wanted to work there and she'd be leaving as soon as she found another job. She also acknowledged that she'd in fact been job hunting while at work. She told her practice manager to her face that she didn't have anything to contribute at the residency and would be stepping back. She confirmed she was very angry with the practice manager and with the doctor and with the practice manager supervisor, among others. She'd openly expressed to coworkers her ill feelings about the management of the practice in the workplace. She continued to unload on the practice manager, telling her she didn't even think she should be the practice manager. And she expressed her dislike for, quote, the nastiness in the front from you and throughout the residency. HR then decides we're going to let her go. They terminate her on December 19th due to the negative working environment she's creating, and they said they would pay her for her 2-week notice period. She attempts to cloak her behavior as victimization akin to domestic violence and receiving punishment for allegedly causing the violence and then being retaliated against for having complained. She misperceives the dynamic in play at the residency. This patient is hardly in a position of power. There's no question he behaved inappropriately. There's no question that she handled it poorly and likely made a bad situation worse. That's not why she lost her job. She was unable to accept that she had perhaps mishandled the situation and that her colleagues wouldn't back her up. She was angry that the medical director wouldn't discharge this long-term patient for his comments. The practice manager investigated her concerns by talking with all who were witnesses. She spoke with the patient, got his apology, got assurances he would guard his language in the future. When she claimed he later spoke insultingly of her, she confirmed with the other employees that he in fact been appropriate. The practice found no evidence that he posed any kind of a threat. They offered to have someone walk her to and from her vehicle in the parking lot. She never took them up. They offered to let her use another office space away from the front desk whenever he would need to come in. She declined that offer and instead decided on her own to go downstairs near administrative offices while she waited for him to depart. It should be noted, this patient was not exactly an everyday visitor to the practice, and his visits tended to be less than 30 minutes when he did arrive. So Ms. Porter disagreed with the medical judgment of the doctor not to discharge the patient from the practice. The patient's behavior may well have resulted in him being removed from other restaurants, retail establishments, and other places where businesses perhaps have greater discretion to choose their customers. Healthcare, particularly in places such as FMR, is not such an industry where the rudeness of the customer is grounds for permanent eviction. The doctor correctly understood her obligations. FMR had the right to assess the facts presented and reach a different conclusion than that Ms. Porter suggested in light of the statements of all involved. She had the right to disagree with those observations and announce her intention to leave. It's the disruptive manner in which she did so that's what really necessitated her prompt departure. Thank you.
Thank you, Mr. Messerschmidt. Questions for respondent, Commissioner Whitworth,
No questions, thank you.
Commissioner Ashby,
No, thank you.
Commissioner David,
No.
Commissioner Dusan,
I have no questions.
Commissioner O'Brien.
All set, thanks.
Okay, complainant actually used all of their time. Mr. Messerschmidt, you have about 2 minutes left if you want to use them.
I don't need to, thank you.
Okay, thank you. So then we will turn to the investigator, and this case was, and I'm sorry, I just asked to unmute Ms. Garcia, didn't mean to do that. This case was investigated by Milo Gitchos, but the case is being presented today by Alice Neal.
Good morning, Commissioners. I'm Alice Neal. I did review the entire record in this case, including Investigator Gitchos's report. You've heard from the parties what their thoughts are on the case today. To the extent that I can answer any questions for you based on Investigator Gitchos's investigation, I'm happy to do that. And I don't think that he would change his recommendation based on the parties presented today.
Questions for the investigator, Commissioner Whitworth,
No questions, thanks, Alice.
Commissioner Ashby,
None, thank you very much.
Commissioner David,
No, thank you.
Commissioner Dusan,
I have no questions.
Commissioner O'Brien.
No, thank you.
Well, thank you, Alice. So then at this point, we would need a motion or motions. There are two proposed findings.
I'll move to take them together and find that there's no reasonable grounds to believe that respondent discriminated on the basis of sex, nor reasonable grounds to believe that there was retaliation, and the complaint should be dismissed.
Second.
So it's been moved and seconded. Is there any discussion among commissioners? Seeing none. So the motion is to find no reasonable grounds on both claims. If you say yes, you are agreeing to that. Commissioner Whitworth,
Yes.
Commissioner Ashby,
Yes.
Commissioner David,
Yes.
Commissioner Dusan,
Yes.
Commissioner O'Brien.
Yes.
So the vote is 5-0 and both findings are no reasonable grounds. Thank you to the parties. We are counsel. We will send you a letter recounting the findings and explaining the next steps if complainant chooses to avail herself of them. Thank you. You're welcome to stay on the call, but this hearing is over.
So our next case E19-0406 AB. This is a reasonable grounds case recommendation. Valencia Dumas, the United Parcel Service and Teamsters Local Union 340. Is there anybody here for the respondent?
Yes, this is Jack Aaron on behalf of the respondent, and with me is Kim Taylor from UPS HR.
And so the reasonable grounds finding is there's only one against UPS. And so Teamsters was a no reasonable grounds recommendation. So it would be just UPS that we hear from at this point. So you have 10, I'm sorry, there was Mr. Gearin and Ms. Taylor is with you. So you have 10 minutes, Mr. Gearin.
Thank you, Ms. Snyerson. So I appreciate the opportunity to be heard by the commission. And I'm mindful of the fact that there's a lot in the record and that we will go by what is in the record and not go beyond that. And I'm going to focus on our factual and legal disagreements with the finding. Let me say at the outset that UPS, as the commission is well aware, is a global parcel delivery business providing services throughout Maine. It is a very diverse company of people of all backgrounds, races, genders, gender identities. Ms. Dumas is not the first transgender person to work in Maine. There have been other individuals that have worked there and worked there successfully. And so we would dispute the findings of the commission that there was any level of discrimination here, and particularly the findings that there were complaints made that were somehow not investigated or ignored. Kimberly Taylor, who is the head of HR from UPS, is available here today and happy to speak to any of specifics that the commission is interested in. And Kimberly Taylor herself took a very hands-on approach with respect to any complaints that were made from Ms. Dumas. She has an in-depth record, an in-depth knowledge, as I do as well, based upon the record of the fact that there was one complaint that was made with respect to Ms. Dumas's gender. There was a question someone asked her inappropriately about her gender, and that individual was followed up with. I'm not going to mention names because I know the commission's admonishment about that, but that individual was followed up with, warned. That individual apologized to Ms. Dumas. There were other complaints, not really along the lines of being discriminated based upon gender identity, but there was an issue with how an injury in the workplace was handled. There was an issue with respect to sort of generalized complaints in terms of her workload and how she was being treated and her desire to be promoted to a driver, a position that another transgender individual in the state of Maine was in fact promoted to. And every time that, as we set forth in our position statement, every time that Ms. Taylor followed up with Ms. Dumas, she was told that things were being handled, that she was happy where she was happy with the investigation that had taken place. She thanked Ms. Taylor for the investigation that took place. And, you know, in terms of the promotion issues, unfortunately, Ms. Dumas was not able to recite what she needed to be able to recite in order to become a driver. And there was a special accommodation made where Ms. Dumas would be able to do the reciting of the 10 habits that every driver needs to be able to recite, and the 5 safety points, I believe it is, 5 seeing habits. And there was an accommodation made where she was able to do that in front of her own supervisor back at the facility, as opposed to doing it at the training site. So we respectfully disagree with the investigators' findings. I will note that, as I pointed out in our statement, We were not aware that there was a preliminary ask for a hearing in this case. We did not receive a notice of that. I understand that I have no doubt that it was sent out by the investigator, but we did not receive any notice of a preliminary hearing. We don't have any docketing record of that. The union apparently didn't receive one either, as they did not attend the preliminary hearing. And Ms. Dumas will have the opportunity to speak for herself, but she didn't attend the hearing either. And so we received, after some time of this investigation going on, we received a notice of a probable cause finding, and we frankly, respectfully feel that we should have had the opportunity to follow up if there was any additional information needed or factual questions. There are several, respectfully, errors that were made in the factual findings. For one, there's an indication that there was no record of any trainings that took place. And so it seems that every factual question seems to have gone in favor of Ms. Dumas without any follow-up with us. And in fact, there are contemporaneous notes that trainings did in fact take place, that there was a follow-up and a warning with the individual who made the comments. There were several trainings that took place on site, and Ms. Taylor could certainly speak to that. And that was documented in the records. To the extent the commission was interested in getting additional records or, you know, copies of PowerPoints or something along those lines, we didn't receive any additional requests for that. So, you know, that was, I think, an unfortunate piece that went against us, and I don't think we've really had a fair opportunity to respond to. There was also, and a lot of this is done in the footnotes of the decision, but there's also a note that says UPS then assigned Ms. Dumas to work for her primary harasser. Well, respectfully, we don't know who her primary harasser was. We know who this individual was alleged to be. We know that there's an allegation against this one individual who was a co-worker. It was investigated. It was promptly stamped out, and the individual was spoken to. And as I said, he apologized to Ms. Dumas. In terms of the other individuals, again, I'm not going to mention names, but we are fully prepared to have, you know, other individuals, supervisors or individuals from the union. They were a party as well, and they were not found against, but we were certainly ready and willing to make people available so that their credibility could be tested, or there could be questions about follow-up, because our position is there was one complaint that had anything to do with a gender-based comment. And so there's a lot of salacious allegations in the record about inappropriate comments, some really salacious and untoward comments, and we get that, and UPS doesn't tolerate that. And as I said, we've had success with other individuals that have identified as transgender, and so there's no tolerance for that at UPS. Ms. Taylor jumped on every single complaint. She did receive a couple generalized voicemails and emails, and every time, or text message, every time she followed up with Ms. Dumas, the sense was given that things had been investigated to her satisfaction. And there's other instances of that in the factual findings as well. For instance, there's a footnote that says, well, there was another individual that's believed that they were not able to recite the safety points, and they were not transgender or didn't identify as transgender, and they were allowed to become promoted to a driver. You know, that just simply isn't true. 90% of every UPS driver you see out there, some come in laterally, but about 90% of them come in as package handlers, and they are then promoted up through the ranks, in fact, as Miss Taylor herself was, and go on to become cover drivers or other types of drivers, or move up administratively in the company. And they all have to recite those safety points. And that's something that Ms. Dumas, despite being given a special accommodation to, because she expressed some anxiety about citing it at the training center, she had the opportunity to do that back at the site, and she simply wasn't, you know, unfortunately unable to do it. And then Ms. Dumas expressed some desire to leave the company and go work as a driver for the state. And the company took the position that they would support her in that effort, and that they would, you know, she was a part-time employee. And while they were happy with her work and happy to have her stay, she indicated that she wanted to move on. And they said, well, you can do that. If you want to attend classes, you can do that, but we'll have to change your shift. And that was agreeable to Miss Dumas, and that's what occurred. And I don't know where that went in terms of whether she was able to eventually become a driver working for the state at another company. But then she abruptly resigned from the company. And when Ms. Taylor followed up again, the message that was received back was, no, I didn't inform you. I informed other people. I informed other supervisors. And we understand that while we have proper channels that should be followed, and that's certainly our position, that sometimes these complaints can come in other ways. And we understand that we're responsible for the actions of our supervisors. But there's been no follow-up, as far as I know, from the commission with our supervisors to ask about these other allegations. We know about the allegation where she said she was injured on the job.
Mr. Erin?
Yes.
Sorry, that's your time.
Thank you. So I will obviously stop talking now, but I think I've made our points that we think this should be dismissed, or at a minimum.
Actually, that's your time. Yeah.
Thank you.
Yeah. Commissioner, questions for UPS? Commissioner Whitworth?
No questions.
Commissioner, sorry, my brain is hung up. Commissioner Ashby?
Hi. No, I have no questions. Thank you.
Okay. Commissioner David?
No, thank you.
Commissioner Dusan?
No, I have no questions.
Commissioner O'Brien?
No.
Okay, so then is there anyone, well, since the Teamsters local union did not object, I will turn to Ms. Dumas.
Yes. Hi.
Hi.
I didn't receive any notice of any fact-finding conference either. So I'm not sure what happened. I haven't received anything from the Human Rights Commission until I received notice of this meeting today. So I have multiple witnesses, and there's stuff that's not even in this report that you guys have to hear this. I have pictures that were sent to me on my phone. You guys have to see that.
Just so we know, Ms. Dumas, you can't bring up anything.
I know I can't.
Investigator.
I know I can't bring those up, but I don't think today should happen because I haven't met with anybody to give any more information than the initial thing I filled out online.
Is that all you want to present?
No, I'll keep going, but I'll try and skip over what I think is not in the report. UPS never dealt with my complaints aggressively. I reported to Kim Taylor that I was being harassed by the same guy who asked if I was a man. I also complained that my supervisor was harassing me and sabotaging my work. I left Kim a message on her answering machine regarding that supervisor, and we spoke about both instances in person. I was very clear with her that I would take my complaints to state agencies if she didn't do something about it. Kim then made some comments about her daughter being a lawyer and complained that she now has to open an investigation. She asked if I would fill out some form, and she would get it for me. We walked into the office. There was another supervisor sitting there. She asked him if there was some system on the computer so she could pull up some forms, and she wasn't able to get it and said that she would get it to me later. In regards to notifying Kim that I didn't notify her or call her. No, I didn't call her at the end when I quit because she never would respond to anything, any of the complaints. So I didn't call her when I quit. I text a shop steward and I text my immediate supervisor. I wasn't given the same opportunities as other trainees. My computer didn't work on the first day and a half of the training to become a driver. The person training was sick, so she left it up to us and our computers. It took me a day and a half to find an IT guy. And on the second day, he was able to get me up and running into the computer system. UPS says I took this training, so surely they can prove I was actually on the computer taking this training. If they say I did that, which I did not. And I wasn't the only one that wasn't able to recite the 5 seeing habits into 10-point commentary. A brand new hire from Rockland who wasn't in uniform, he wasn't able to recite it either. I asked them if I could write it instead, and they said no. When asking other drivers, not one driver could recite them either. A temp preloader who was a holiday driver never even went to training, and he was put behind the wheel by my supervisor, but we weren't supposed to talk about that. A few days before I was to switch to the night shift, a driver came to me and he said that a couple of drivers were complaining because they aren't allowed to grow a beard, and UPS will let a trainee deliver packages. On another day, a shop steward approached me and said that his buddy on the night shift asked him if a transvestite was moving to the shift. Both incidents were brought to the shop steward and 2 of my supervisors, and once again, nothing came out of it. And I was transferred to the night shift to be with my new harassers. The primary harasser, he would come to work every day around 7, and he wasn't even supposed to be there until about 8:45, and he would hover inside the truck. At one point, he even put his hands down his pants and put his finger out through his zipper. And at first I thought it was his penis when I saw it. He always commented on my breast. He would even rub against the back of me in the back of the truck and would blame it on the close quarters. He should not even been on the truck or anywhere near me until at least 9 a.m. He also at one point sent me pictures of his penis. I still have the phone, and I'll give you permission for the phone records if you need them. I did not request the night shift. I requested to leave work a half hour early for 30 days so I could attend a class. My supervisor denied it, but he said I could put a request in for the night shift because they needed help. I assumed the switch would be for 30 days, but after I made the switch, the supervisor said that I would have to stay for at least a year. UPS states trainings did not took place. I am saying they did not. I do want to mention though that 2 separate Metro supervisors approached me and apologized to how I was being treated. Let's see. So I know that I was being talked about to the supervisors. Let's see. The one Metro supervisor personally told me that if he ever witnessed somebody treating me that way or heard anything, that he'd fire them on the spot. What started out was section gender discrimination ended up becoming sexual harassment after I accepted the apology. Every day that person would show up at 7 a.m. and come on the truck and harass me. Some days it was sexual harassment, other days it was just fine, but it was continuous and it never stopped until I moved to the night shift. I made another complaint against my immediate supervisor who was sabotaging my work, and it was not vague and it was not unsubstantiated. His supervisor called me personally at home after work to find out what was going on because another supervisor reported him what my immediate supervisor was doing to me. Also, the heat wasn't working in the loading area, and the supervisor thought it was funny, and he would specifically mess up the conveyor belt, so all my packages would get backed up, send them down to me. I ended up getting hurt, and then he would make fun of me and told me to enjoy my misery after I got hurt. He also would make vulgar comments to the other girl that was working with me also, but she was too afraid to say anything. The girl that I was working with, she also heard the comment that he made to enjoy my misery. And she also told his supervisor what he had said. The other dispute was with a girl. She was mad because she didn't want me working around her and accused me of creating a safety hazard and tried to get removed from working around her. After she didn't get her way, she then complained to Kim Taylor and 2 other of my supervisors that she was afraid of me and didn't want to work around me. After I moved to the second shift, the harassment from the original harasser stopped, but the harassment continued from the night shift. Trucks that I would be responsible for would be purposely parked on the other side of the UPS property than where they belonged. The worker would close the overhead doors on me and lock me out at night while I was trying to catch up from the other workers messing with me. The night shop steward and another female UPS worker would video from their phones myself and another supervisor who they didn't like. They were hoping to catch him doing something that would get him fired. That shop steward and another guy on the night shift who refused to do their work. If I was allowed to wash my trucks before them, the night shift supervisor told me that to let the men finish the jobs first. That was my last night of work. I wasn't going to be dealing with them locking me out of the building again before I had a chance to finish my job. I left a text message for the night supervisor and the shop steward and told him I quit. UPS did not give a hands-on approach to this harassment. The toxic culture at UPS is very pack-like. I was targeted and harassed daily. It was at the point where I only spoke to a couple of people. I never even took break and never even went to the break room anymore because I couldn't stand the people I was associating with. I still have the cell phone and the pics. I don't think the actual photos are on my phone, but I'll give permission to the phone records to be released. Lastly, UPS states that I never filed an injury report. That is not true. I tried to report the injury 3 times and every time I was denied by my supervisor. I brought a shop steward with me. He was a witness every single time I requested to file the report. Shop steward even went to the supervisor about it and he denied that I even asked him for it, even though I had a witness. I decided to seek treatment on my own through Maine General. And it wasn't long after treatment started that I was out on medical leave and in emergency surgery for kidney stones. I immediately turned to work after surgery and loaded trucks with a stent in my kidneys for 2 more weeks. And that's it. That's all I have.
Wow,
Thank you.
that was exactly 10 minutes. I will say there was one thing you mentioned, something about a penis picture. That
I'm
was
sorry.
That was
I
not
know
on
it
the
wasn't.
record. Yeah.
But that's why I'm so upset about not being able to see the investigator because I
understand.
would have provided all of that.
I understand, but your time to present is finished.
Okay, thank you.
So at this point, I'm going to ask the commissioners if they have any questions for complainant. Commissioner Whitworth,
No questions.
Commissioner Ashby,
None, thank you.
Commissioner David,
No, thank you.
Commissioner Dusan,
I do not, thank you.
Commissioner O'Brien.
No, thanks.
Okay, so now we've heard from both parties. Mr. Gearney used all your time. So at this point, I think, Barbara, I need to inquire whether there's anyone here for Teamsters. Is that correct? Yes. Is there anyone here who wishes to present on behalf of Teamsters? Teamsters Local Union 340.
Their attorney seems to be here.
He is here, but Mr. Riot let me know ahead of time that he's here for another case and that the union had made a determination not to have him present for them on this. So I was just seeing if there was anybody else here.
Okay.
Teamsters.
May I make one comment?
No, nope. You may not. Thank you. So at this point, we are going to turn to the investigator. And again, this was a case investigated by Mr. Milo Gitchos, and today Bob Beauchesne is presenting the investigation.
Thank you. Good morning, commissioners. Just to cover a couple of points, in this case, the investigator concluded that despite the respondent's assertion that it investigated and appropriately addressed all of the complaints of discrimination, its attempt at corrective action appeared to be ineffective given that the alleged harassment based upon sexual orientation appeared to have continued right until the very end of complainant's employment. And the respondent had alleged that it had no way to determine who the individual referred to as the primary harasser in the report was. In complainant's rebuttal, that specific incident refers to the individual's first name, and it's the same name that was involved in the initial problematic question near the beginning of her employment. So even if this training was or was not held, it didn't appear to make a difference, since these types of obscene comments were allegedly still being made just prior to her moving to the night shift. And again, the idea that this individual, even if he had apologized at the front end, forcing or assigning her to work in close confinement with that individual on a daily basis appears to minimize the severity and the impact of the inappropriate question to begin with. So the investigator found complainant to be credible on that point. And again, and assuming that that was taking place by the same individual that had been initially counseled about asking inappropriate questions, certainly in the investigator mind appeared to give rise to the hostile work environment, especially when coupled with other alleged less favorable treatment that were referred to, the injuries being ignored, being removed from the driver training program, not being made aware of any alleged workplace harassment training that did take place, and the last incident that was mentioned where she was directed to stop washing a truck so that males could wash their trucks before her. So again, I don't have a specific explanation as to why the conference was apparently scheduled but never held in this place, aside from the indication that none of the parties showed up for the conference itself. So again, I believe in this case, the investigator, based upon the information on the report, found that while individual complaints that complainant made were investigated, it still didn't stop the harassment from occurring. And that certainly, if it occurred on the frequency the complainant has represented, that would certainly satisfy the pervasive prong of that showing. And the severe could certainly be proven in this case by the use of such offensive terms as tranny and transvestite and these work rumors that were still going around just shortly before she decided to resign.
Thank you, Bob. Questions for Bob on behalf of Milo? Commissioner Whitworth?
No questions.
Commissioner Ashby?
Thank you, Bob.
Commissioner David?
Bob, this may be unfair to you since it's not your report, but am I correct that the only discipline I see referred to other than counseling and speaking to people is a single write-up in an employee's file? Does that appear to be the only discipline administered by the company?
Well, again, are we talking about the initial incident where the inappropriate question was asked, or some other event?
The whole, through the whole course of the.
He's saying anytime.
I'm saying
Again,
anytime, yeah.
There's not extreme detail as far as the type of discipline that was issued, again, probably given the privacy of those records vis-a-vis management to the offending individual. That was the only information I saw. I did see again that there were a number of instances, including apparently the final incident involving these rumors that were coming about, that apparently at that time, the complainant indicated that she did report these offensive rumors and that apparently supervisors immediately addressed the situation with one of the offending parties and somebody else was to speak to the other offending party. And there was an indication that the entire night crew was spoken to as a result of these rumors being spread near the end. Whether or not that resulted in any formal discipline, there's nothing in the record that would tell me one way or another. But again, there was a situation apparently where it was severe enough that essentially people stopped in their tracks and confronted the entire night crew about these rumors going around about complaining. I don't know whether that was formal discipline or not.
Well, he only notes the one formal discipline. Mitch only notes the one formal discipline of a write-up in a file.
Yeah, I have no reason
So-
to doubt that. And again, and I guess it's definition as far as whether or not a counseling is considered some form of discipline or not. But again, that was the only one, and I think responded represented that individual did receive some type of discipline for that initial question, as well as offering complainant an apology shortly thereafter.
Thank you.
Commissioner Dusan,
I have no questions.
Commissioner O'Brien. I believe you're saying, no, you do not have any questions. Okay, thank you. Thank you, Bob. We've heard from the parties and from the investigator. At this point, we would need a motion or motions. Might be better to handle these two. Well, actually, you know what? It doesn't matter. You can handle them together or separately. But someone is going to have to speak.
I'll
move
move
that-
that there are reasonable grounds to believe that respondent discriminated against the complainant and the claim should be conciliated.
Which
and that there are no
respondent?
reasonable.
Which
uh,
respondent?
Yeah, United Parcel, the first one. And that in regards to the second one, that there are no reasonable grounds to believe that the union discriminated and that should be dismissed.
Second.
Hold on. So your motion was to adopt both recommended findings?
Yes.
Okay. Okay, so the motion is to adopt both recommended findings, reasonable grounds related to UPS, no reasonable grounds related to Teamsters. It's been seconded. Is there any discussion by commissioners? Seeing none. Okay, so so the motion is reasonable grounds to believe the UPS discriminated against Ms. Dumas on the basis of sex and or sexual orientation, and no reasonable grounds to believe that Teamsters discriminated against Ms. Dumas on behalf related to sex or sexual orientation. If you say yes, you agree with those two proposed findings. Commissioner Whitworth?
Yes.
Commissioner Ashby?
Yes.
Commissioner David?
Yes.
Commissioner Dusan?
Yes.
Commissioner O'Brien?
Yes.
So the findings are reasonable grounds to believe that UPS discriminated on the basis of sex and sexual orientation, and no reasonable grounds against Teamsters, Local 340. And the commission will send council and the parties a letter outlining the findings and the next steps in the process. We appreciate your participation today. You're welcome to stay on the call, but this hearing is finished.
Thank you.
Thank you.
Thank you for your time.
Okay, our next case, E19-0500, Dustin Broughton v. Town of Dixfield. It's a, well, no reasonable grounds. So is there somebody here for the claimant?
I haven't seen a name that would indicate that he's on the call, and we did check our voicemail to make sure there wasn't a voice message from him saying that he was having trouble logging on. We haven't seen anything like that. So typically when the party opposing the finding, the recommended finding does not appear, typically the commission would vote to adopt the recommended finding.
So moved.
Second.
Wait, hold on. Wow, that was too fast. I missed the whole thing. Hold on. So that was Ed made the motion
Yes.
and the second was Jill?
Yes.
Okay, thank you. So it's been moved and seconded to find no reasonable grounds to believe that the town of Dixfield discriminated against Dustin Broughton on the basis of sexual orientation. No reasonable grounds to believe that the town retaliated against Mr. Broughton for engaging in protected activity. If you say yes, you are agreeing with both of those proposed findings. Commissioner Whitworth.
Agree.
Commissioner Ashby.
Yes.
Commissioner David.
Yes.
Commissioner Dusan.
Yes.
Commissioner O'Brien.
Yes.
Thank you. So the findings are both no reasonable grounds. Thank you for being here, Ms. Greco.
Thank
And
you
I'm
very
sorry, I've just probably mangled your name as well.
No, you did perfectly fine, as Mr. David will tell you.
Thank you very much. Okay. Deb, moving on.
Sorry, our next case is E20-0011AB, Christopher Allen v. Matheson Trigas and Robert Smith. Is there anybody here for the claimant?
Yes, I'm here. This is Sam Riot here on behalf of Mr. Allen.
Okay, you got 10 minutes, Mr. Riot.
Okay, thank you. My name is Sam Riot. I'm here on behalf of Mr. Allen in representing him in his case for age-based discrimination and his termination. Mr. Allen was fired by Matheson on February 11th, 2019. And when he was fired, he asked his supervisor who fired him, "Why are you doing this to me?" And his supervisor responded, "Because Matheson needs somebody younger who can give 150%. Now, Mr. Allen's not an attorney, but when he heard that, he thought to himself, man, that doesn't sound right. I want to get to the bottom of this. And in that process, Mr. Allen requested his personnel file, and he also requested a copy of some audio-visual recording he believed would depict him getting fired, that you could hear the language that was used by his supervisor. And the reason Mr. Allen believed that the audio-visual recording would capture all of that is because he was told by the individual who was installing the equipment a few months prior that, hey, what the guy said to him was, hey, be careful around this because it's not only capturing you visually, but it's also going to capture what you say. Mr. Allen did receive responses to both of those requests with respect to the personnel file and the audio-visual equipment, and they did not do anything to dissuade Mr. Allen from his belief that what happened to him was not appropriate and was illegal. With respect to the personnel file, in it, there were a number of documents that purported to show Mr. Allen's signature that he is adamant he did not sign. One of those documents is a performance evaluation that Matheson relies on to demonstrate in this process that what Mr. Allen was fired for was performance related. The problem with that document is twofold. One, it does not have Mr. Allen's signature on it. Well, it does, but it's not his. And more importantly, that document is dated September of 2019. So it's a performance evaluation for Mr. Allen that's dated 7 months after Matheson Trigas had fired him, that Matheson Trigas is using to justify its termination decision and claims Mr. Allen signed. But again, it's dated September of 2019, which is well after Mr. Allen had been fired. Now, Matheson claims that there's a justification for this mistake. It's just a mistake, that it was a clerical misdating. But it's a hand-signed, hand-filled out performance evaluation. And I just don't think it's credible that people make dating mistakes and date things for the future. I'm not writing 2022 right now. I suspect that many of us, if not all of us, are also not writing 2022 right now. Yet that's what Matheson would ask you to believe is what happened with this particular performance evaluation. Secondarily, the audiovisual response that Mr. Allen made and requested that he got was not complete from his perspective. And that's because A, it did not include any audio of what was being told to him at the time. And also the video itself, at the precise moment that Mr. Allen believes he was terminated, the video jumps forward 30 seconds. Now, when you watch the video, which I believe a copy of has been provided to the Maine Human Rights Commission, when you watch it, you also realize that the video is not sort of the original format of how the recording system recorded it. What you're seeing, I think, is someone holding a cell phone camera up to a computer and recording that. So that might be the reason why there's not any audio. I don't know. All I do know is that I agree with Mr. Allen that all of these things together raise as many questions as well, they don't answer any questions, just raises a lot of questions about the veracity of what we're looking at. As for the investigator's report, when the investigator concluded that there were no reasonable grounds for Mr. Allen's complaint, it did so by saying that Mr. Allen had not presented any evidence that the documents were altered or otherwise sort of illegitimate. But the question I have is how that was how that conclusion was reached, because during the Issues and Resolutions Conference, there was no inquiry about any of these issues by the investigator. The investigator never asked about the signatures that Mr. Allen said weren't his. The investigator never asked about the misdating of the document, the performance evaluation that Matheson relied upon to justify its termination. The investigator never asked about whether or not there is audio as well as video for that particular recording, or why there was a big jump in the video that we believe erased essentially the moment in time when Mr. Allen was terminated. What the investigator did ask about is the investigator did ask the supervisor, hey, do you remember saying that Matheson wanted to get rid of Mr. Allen because they needed somebody younger who could perform or work at, give 150%. And Mr. Allen's supervisor didn't explicitly deny saying that. What he said was, I don't remember. Which is different than a denial. Certainly, that doesn't mean, just because you don't remember something doesn't mean it didn't happen. But one would hasten to guess that if a person had not said that, they would know explicitly, I never said anything like that. But that's not what we heard from Mr. Allen's supervisor. And finally, I think what underscoring all of this is that the biggest issue Mr. Allen has with the investigator's report is that it sort of says all of what I just said, that none of this evidence has been proven by Mr. Allen. But more importantly, Mr. Allen himself admitted at the Issues and Resolutions Conference that he wasn't performing the duties of his job. And that just didn't happen at the Issues and Resolutions Conference. At the outset, we were hoping that it would have been recorded. We were told that the whole conference was going to be recording, but there was a technology issue. So we don't have that recording. But my notes, there's no indication. Mr. Allen is adamant that he denies ever admitting that he wasn't doing his job because he did his job. There was some discussion in general about how busy that particular location was for Matheson, and that there was some discussion amongst employees about, man, we've got so much work, how are we going to get this all done? But Mr. Allen reasserts his denial, which I think he said something in various affidavits, but he denies failing to perform the duties of his job and does not understand how the investigator came away with that admission from the Issues and Resolutions Conference. So just tying things up, I think that at the end of the day, all of these discrepancies certainly give evidence of pretext to what I would call direct evidence that was given to Mr. Allen when he was fired, that they were looking for someone younger. And so as a result, I think that the commission should find that there are reasonable grounds for Mr. Allen's complaint of discrimination and decline to advance the conclusion reached by the investigator. Thank you for your time. I'll take any questions.
Thank you. Hold on just one second.
Mm-hmm.
Okay, so questions for complainant. Commissioner Whitworth.
No questions.
Commissioner Ashby.
Yeah, I don't want to sound argumentative when I ask the question, but you seem to suggest that the supervisor who said, I don't remember mentioning age, we're to infer that if the complainant said he did mention age and the fellow said he didn't remember, then we should perhaps find that fact in favor of the complainant. The affidavit, though, submitted with your submission by your client, when he addresses the issue of acknowledging that he was not a good employee at the Issues and Resolution Conference, he says in two different paragraphs, I don't remember making those statements. So he does sort of the same thing. Do you share maybe my concern that that's not a very full-throated denial at the Issues and Resolution, that he made admissions at the Issues and Resolutions Conference that he was a bad employee?
Are you saying that I didn't quite understand your question. Can you rephrase that for me? And I'm not trying to be difficult. I don't quite understand.
No, I'm wrestling with this myself. All right. Okay. So your argument just now was that the supervisor who said, I'm looking for someone who'll give 150%, and I don't remember mentioning younger employees. You're suggesting that because your client says that he said younger employees, that we should make an inference that fact is true, because when the fellow said it, he said, I don't remember making that comment. Is that what you would like us to do?
Well, I think what I'm saying is that Mr. Allen, my client, is adamant that when he was fired, and he asked why, his supervisor told him because Matheson needs someone younger who is willing to give 150%.
Right.
And at the Issues and Resolutions Conference, when the supervisor was asked whether he said that about Mr. Allen and Matheson's motivation for terminating him, the supervisor didn't say, no, I didn't say that. All he says is, I don't remember saying that.
Right.
And all Mr. Allen, I think if I'm hearing you, what I would say is that Mr. Allen is not suggesting that the lack of an explicit denial should mean that he said it. He's just saying that it's peculiar to him that the supervisor was not more full-throated in denying the discriminatory statements than he was.
Okay, good. So moving forward then, our investigator wrote that your client admitted at the IRC to making costly mistakes and that his performance was not as good as it should be.
Right.
Yet in his affidavit, your client, the complainant, says, I don't really remember making those statements at the IRC and therefore deny it. Do you see the parallel here?
I mean, I don't think that, well, I think that my client's affidavit, and I'm assuming you're talking about the one that's dated August 19th, 2021. I mean, he says, I do not remember stating at the Issues Resolution Conference that I was completing all my data. Instead, what I remember saying, what is true, is that all employees, myself included, would discuss how much work we had to do and that there was not enough time to complete it all. So I think that I understand the point you're making. Yes, I understand what you're saying. But I do think that, if you look at paragraph 3, it says, in fact, I deny that I made any costly mistakes. So but I do understand your point. Yes.
I mean, we're going to be wrestling with believing our investigator or not. Our investigator says, I found certain facts, and your client isn't saying, I absolutely did not say those things at the IRC.
Well, right. I mean, I think it's fair enough. I think I think that we all have to remember, and that's, I mean, your point is well taken. He denies that he can't. I mean, it's, I guess what I would say is that at the IRC, we don't know what. I think he was reluctant to say anything about what he said with certainty, because certainly, I'm trying. At the same time, we're trying to be respectful that people might have different memories or different takeaways from the same sentence. Right. What he's saying, I think, in his affidavit, and he's not here, is that, look, those facts aren't true. I did not make costly mistakes, and I don't remember saying anything like that at the conference. But nevertheless, it's almost like I don't think I would say that because they're just not true, but I can't say with 100% certainty that I didn't say them because I don't have an audio, I don't have a recording or a transcript of what was said there. And I think that we're all should be aware, at least, that we don't have, sort of lock boxes in our brain that record exactly what was said at a particular moment in time in the past. But nevertheless, he's saying, I wouldn't have said those things, I don't think, because they weren't true then and they were never true.
Thank you.
Okay. Commissioner David, questions for complainant?
Yes, did he get the required certification, and if so, when?
The certification for the driving? Yeah, he did at some point. I don't know exactly when, but he did go down. I think he was given a day off to drive to Augusta to try and address the fact that what he had sent in seemed to not be processed. And I believe that effort, that day, he did obtain the certification. Yes.
Thank you.
Commissioner Duson?
No questions.
Commissioner O'Brien, questions for complainant?
No, again, not now. No, thanks.
Okay, thank you. So Mr. Riat, when we come back to you, you'll have about 3.5 minutes left.
Thank you, Ms. Nearson.
Now, is there anyone here for Matheson Trigas and Robert Smith? I don't see their counsel. Which is, okay. Well, typically, if so Mr. Riata, you have another 3.5 minutes if you want to use them.
I think I've said all that I need to. I don't want to waste anybody's time. So I have nothing further.
Okay. And I thought the gentleman who just left, which was Sam Martin, I thought he was here from Matheson Trigas, but their counsel, I just checked, did get notice of the hearing. And so I'm not sure what to make of that, but at this point, we would turn to the investigator. Ms. Brindley.
Good morning, everyone. My name is Alex Brindley. I was the investigator in charge of this investigation. So regarding the few points that Sam Riat brought up. So during my conference, there were some technical difficulties. So it wasn't recorded. However, I did take notes while the meeting was occurring. And according to my notes, the conference, in fact, admitted to making mistakes. Whether they were costly or not, I cannot remember. I did not make note of that. The conference was in March, so I cannot remember, but he admitted to making mistakes. He also stated that he could not complete his daily tasks because there weren't enough time. Now, in regards to...
Alex, could I ask you to pause for just 1 second? Mr. Martin?
Yes.
You're from Matheson Trigas, right?
That's correct. And Mr. Smith as well.
Oh, okay. Were you planning to present on behalf of?
I was. My internet just dropped out as soon as I was about to come start talking.
Okay. So Alex, I'm going to ask you to pause and we will come back to you. Okay. So I'm glad you're back, Mr. Martin. So you have 10 minutes. And commissioners, sorry about that. Pull back from investigator mind. Let's come back to parties discussion. Okay, Mr. Martin, you have 10 minutes.
Thank you. Good morning, everyone. My name is Sam Martin. I represent Matheson Trigas and Mr. Smith. I apologize for my internet dropping out at the worst possible time. We asked that the commission adopt the investigator's report in this case. The investigator recommended no reasonable grounds, and that was upon two bases. The first, that the prima facie case was not satisfied because the complainant could not show that he can perform his job satisfactorily. And this finding was based on an admission that complainant made to the investigator at the IRC, where he said that he had made costly mistakes and he was not completing all of his daily tasks. This was documented by Matheson through two write-ups and documenting two serious performance issues during his employment. The first was the failure to get his hazmat certification. That began at the beginning of his employment. In fact, he was sent to Matheson's facility in Texas to be trained for this. After coming back, he did not take steps in a reasonably quick manner to get the certification, and it went on for a prolonged period of time. The second was repeated issues with customer service, and there were complaints from coworkers and from customers regarding his customer service. He was documented, written up for that on April 5th, 2018. And eventually those issues continued to grow worse, and he was counseled and did not correct his behavior. In fact, his behavior became worse, which resulted in the choice to ultimately terminate him. And like I said, the investigator did find that the complainant admitted these performance issues at the IRC. And the second ground was that the manager who had hired him was in fact older than he was, and was fully aware of the complainant's age at the time of hiring. And that was only a couple of years before the termination. So his age had not significantly changed. He was hired and terminated by the same individual who was in fact older than he was. And there was no evidence that age was a motive in this case. And I'll touch briefly on the issue of apparently the complainant's counsel is pointing out that the manager, Mr. Smith, had said that he did not recall bringing up age at the time of termination. I would just suggest that the investigator was correct in finding that there was no direct evidence based on that statement that disputed the complainant's claim that it was brought up. And I'll just close by saying that the issue that complainant's counsel raised now regarding his statements in the affidavit, that he was not 100% in recalling what he said and couldn't be totally clear, those seem to undermine his contention that Mr. Smith's statement that he did not recall making the age discrimination statement should not be credited. I think both of those cannot be true. And that's all I have. I just asked that the commission adopt a no reasonable grounds recommendation from the investigator, and I'm happy to take your questions.
Thank you, Mr. Martin. Someone's got some feedback going. So commissioner questions for respondent. Commissioner Whitworth?
No questions.
Commissioner Ashby?
Briefly, counsel for a complainant makes a pretty compelling argument that the September 28, 2019 review, 7 months after his termination, seems a little suspicious, don't you think? I find it convincing that we don't very often post date things a year in advance. Can you help us sort of understand what happened there?
Sure. So my understanding is that it was improperly dated, that the company certainly didn't fabricate this. And I think the investigator has dealt with the issue correctly. And I'll also say that I don't think that write-up is actually necessary to the investigator's finding here, that the admission by complainant that these write-ups were valid and that he didn't perform his job adequately to the investigator is really all that's necessary to make that finding. That his own admission to the investigator corroborates what that write-up says.
So we're going to hear from our investigator in a minute, but and maybe I'm mistaken, but I don't know that she addresses it at all in her recommended findings. I don't think she discusses really the peculiarity of the strangely dated evaluation. And perhaps the evaluation isn't necessary to get to a point where it's sort of a good argument that he should be terminated for cause, but it certainly hurts the respondent's case, don't you think, if it was in fact fabricated, right? Because that changes the complexion of the case completely.
Well, respectfully, I think there's no evidence that it was fabricated. There's conjecture that it may have been. There's no actual evidence that it was. There's no reason to believe that it would have been, given the strength of the rest of the evidence that the commissioner, that the investigator found. And once again, I think it's not necessary given the admission, essentially, that its contents were correct.
Commissioner Ashby, anything else?
Yeah, almost that. Thank you.
Okay. Commissioner David, question for respondent?
No, thank you.
Commissioner Doosan?
No, I don't have questions.
Commissioner O'Brien?
No, thanks.
Okay. Mr. Martin, you have about 6.5 minutes left, but first we're going to turn back to Mr. Riot. I'm going to give you another chance to use your 3.5 minutes if you would like. Nope, you're muted. Nope, muted.
You'd think 18 months in, I would have figured.
Yeah, we all do it. Yeah.
Maybe by 24, right? Hopefully not, actually. No, I don't think that, with respect to this issue of whether or not Mr. Allen admitted anything with respect to his job performance, I dispute that it can be concluded that Mr. Allen has admitted what was. Well, it sounded like Mr. Martin sort of suggested that Mr. Allen had admitted that the details included in the performance evaluation were that he admitted that the performance evaluation's details were correct. I don't think that that's what the investigator says. I don't think that the investigation really relies on any other, as Mr. Martin suggested, other compelling evidence. I think that Commissioner Ashby sort of touched on Mr. Allen's perspective, which is that there's a lot of questions here about the propriety and veracity of a lot of materials that were provided by Matheson that no one's really asked about. And without talking about those and getting to the bottom of their legitimacy by asking Matheson about them, it's very hard to assess what is and is not true. I do think that if Mr. Martin's position is that Matheson was justified to terminate Mr. Allen, regardless of that performance evaluation that's post-dated, as Mr. Ashby said, that means that essentially Mr. Allen was fired in February of 2019 for something he was written up in almost a year earlier, and without any intervening issues arising as to Mr. Allen's job performance. And that to me seems like a bridge too far, both literally and figuratively, with respect to the decision to terminate Mr. Allen. And so to me, there's just enough questions swirling about the signatures and the dates and the content of these materials that Matheson is justifying or is using to justify its termination decision to warrant a closer look at this and maybe question whether or not reasonable grounds are actually the appropriate conclusion here. Thank you for your time.
Any follow-up questions for complainant, Commissioner Whitworth?
No questions.
Commissioner Ashby?
No, thank you.
Commissioner David?
Attorney Riat, your burden is still to prove that there's age discrimination, right? Even though there's, and you're saying the uncertainty about dates and such means that all that should be discounted?
No, I think what I'm saying
yet there's still proof of. Go ahead.
Sorry. I interrupted. I apologize for that. If you would you like? I don't know if I heard your question.
Go ahead.
No, I was just going to say, I think that the basis for Mr. Allen believing that age was the determining factor for his termination is that he asked why I'm being fired when he was being fired, and he was told because Matheson wants somebody younger. I think that right there is the basis for Mr. Allen's perspective. And when he dug deeper and requested more evidence to prove that, the materials he received in response were either incomplete or of questionable veracity. And so I believe that those two things taken together, the statements by a supervisor plus the questions about a number of the materials provided by Matheson together form a reasonable conclusion that age was the reason for Mr. Allen's termination.
But we discount that he said before that he needed somebody that would give 150%.
Well, to me, that nests very nicely into typical statements that are made towards people who are being fired for age. It implies that Mr. Allen couldn't work hard enough, or he was slow, or he was getting on his age. And I believe that that is additional pretextual evidence that supports the underlying conclusion that Mr. Allen and I have taken in this, is that was essentially additional evidence to bolster the age-related basis for Mr. Allen's termination.
That's all. Thank you.
Commissioner Dusson, questions for complainant?
I have no questions.
Commissioner O'Brien?
No, thanks.
Okay, thank you. Mr. Martin, you have about 6.5 minutes left if you want to use them.
Thank you. I'll just quickly rebut something. There's a suggestion that there were not performance issues between the September 2018 write-up and his termination of February 1st, 2019. That's not the case. There were performance issues, and those are what actually gave rise to termination, and that he complainant refused to answer the phone on weekends when questioned about not completing his assigned tasks. And he complained there wasn't enough time to complete his assigned task. And those were the performance issues in 2019 that gave rise to the ultimate decision to terminate him at that point. So it's not that there were not performance issues after that second write-up. There continued to be issues. Those issues were not remediated, and then ultimately he was terminated. Thank you.
Follow-up questions for Mr. Martin, Commissioner Whitworth?
No questions? No.
Commissioner Ashby?
No, thank you.
Commissioner David? Commissioner Dusson?
No.
Commissioner O'Brien?
No.
Okay. Mr. Riat, your opportunity. There's no sir rebuttal. Yeah. At this point, we would turn to the investigator, back to the investigator, where we almost went, Ms. Brindley.
Hello again, my name is still Alex Brindley, and I was the investigator on this case. So jumping off to where I left off, I originally spoke that the complainant had admitted to making mistakes. He admitted to making mistakes, and then he couldn't complete his daily tasks. There were questions about the personnel file in regards to whether or not the signatures that complainant signed were invalid or not. I reviewed the file again this morning. I did not find any discrepancies other than the wrong date in the September 2018 counseling report, but it's signed and dated correctly on the bottom. The only thing that's incorrect is the date at the top. And then moving forward, Mr. Riap brought up the video and how there was a jump in the timeline. So I also reviewed that this morning. There was a jump in the video. However, the jump occurred well after the conversation that complainant and manager had, and it was during the time that complainant was packing up his workstation. So I didn't feel like that was relevant. Then I believe that's it. I believe the respondent brought up everything else relevant. So if you have any questions, I'm open to them.
Thank you, Alex. Commissioner Whitworth, questions for the investigator?
No questions. Thanks, Alex.
Commissioner Ashby?
None. Thank you very much. That was helpful.
Commissioner David?
I think that was very helpful too, Alex. I just want to be clear that the same document, as you review it, has a consistent date, and then at the top has either a intentional misrepresentation or a mistake. Is that right? In the same piece of paper?
Yes, it looks to me like a mistake. Sorry for interrupting. So
Yeah, no, I get it.
like the signatures are similar to past signatures, and the only thing different is the date at the top counseling report, but the date of the occurrence and the signatures that are dated next to it are all the same.
And does the complainant deny the signature?
Pardon?
Does complainant deny the signature?
Not for this
Says it's
counseling
not
report. Not for this counseling
He
report.
does not. Thank you.
Commissioner Duson,
I have
questions?
no questions, thank you.
Okay. Commissioner O'Brien?
Yeah, I just wanted to clarify something about that signature. I thought he denied that he did sign it.
He's denying that the signatures are forged, if I'm understanding correctly. However, if I look at this counseling report and the other counseling reports / documents that the complainant signed, it looks like they're all very similar. I don't see any belief that they're forged.
Okay, thanks.
Okay, one more pass? Any commissioners have additional questions for the investigator? Nope. Okay, thank you, Alex. So commissioners, you've heard from the parties, their counsel and the investigator. So at this point, we need a motion.
I'll move that we find that there are no reasonable grounds to believe that respondent and or the individual named as a respondent as well discriminated against the complainant on the basis of age, and the complaint should be dismissed in accordance with the act.
Second.
Second.
Okay, it's been moved and seconded to find no reasonable grounds on the basis of age. Is there any discussion among commissioners? Seeing none. So the motion is for no reasonable grounds on the basis of age. And if you say yes, you are agreeing with that. Commissioner Whitworth?
Yes.
Commissioner Ashby?
Yes.
Commissioner David?
Yes.
Commissioner Duson?
Yes.
Commissioner O'Brien?
Yes.
Okay, so the finding is no reasonable grounds to believe that unlawful discrimination occurred on the basis of age. And the commission will send the parties and counsel a letter confirming that finding and describing the next steps if anyone wants to take them. That is the end of our morning hearing agenda. So it's 11:15. We have the afternoon session starting at 12. And I apologize that there's a gap there. It's really hard to predict how long things are going to take. But one thing that we could do now, commissioners, is we could do executive session if you would like and get that out of the way. So that would
Please.
shorten our time this afternoon. So then what we would need is a motion to go into executive session that cites the appropriate parts of the Freedom of Access Act. You all have the wording somewhere on a template.
Pursuant to 1 MRS Section 4056E, I move to go into executive session to consult with our attorney regarding pending and contemplated litigation and the legal rights and duties of the commission.
Second.
Well, it's been moved and seconded to go into executive session. Commissioner Whitworth, oh, sorry. If you say yes, you are agreeing to the motion to go into executive session. Commissioner Whitworth,
Yes.
Commissioner Ashby,
Yes.
Commissioner David,
Yes.
Commissioner Dusan,
Yes.
got to show your hand.
Yes.
Commissioner O'Brien.
Yes.
Thank you very much. So now, for everybody who is not a commissioner, or Barbara or Melody or me, I am going to be moving those people who I just mentioned and myself into executive session. You will not be able to hear us. That part of the meeting is confidential as a matter of law. You are welcome to stay on this call or hang up and call back for the noon session. I see a bunch of folks on here who have cases in the afternoon. So that starts at 12. You're welcome to stay on, but we are going to go have an executive session meeting and then come back to this. So theoretically, that's what I'm about to do, is open the executive session breakout room. Here goes.
Amy, can I ask a question? It's Attorney Robert Levine.
Yeah. Oh, hold on. Yes. Yep.
So I got notice of this, but I didn't receive like an agenda, and I don't know when my case is being heard. It's Ho versus Charlie's.
Yep, I'm familiar with your case. We actually, we tell all the parties in council to check our website about a week beforehand for updated agendas.
Okay.
And that's where it's posted. Your case is being heard in the afternoon. It's, I believe, the second case on the agenda.
Terrific. Thank you so much.
Sure.
Appreciate it.
Yep.
Bye-bye.
Okay, so we are back. Do we have everybody back? 1, 2, 3. I didn't actually end the close all rooms. There it is. I didn't do that before. Okay. All right, so we have Deb, Jeff, Ed. So we need Jill and Julie to come back. And for anybody who is still on here and who did not come from executive session, we are taking a break until just before noon when we start the afternoon hearings. Thank you. Hi, the person with the number that starts with 212. I remember you were on this morning and I remember that you told me your name, but I have already forgotten your name. If you could let me know it again and what case you're here for, that would be great. Thank you. Okay, Alice just gave me the name. Thank you, Alice. We're ready. Let's see. We have 1, 2, 3, 4. We have 5 commissioners. We're ready to go.
Okay, good afternoon. I'm Deb Whitworth, and on behalf of my fellow commissioners, welcome you to this meeting of the Maine Human Rights Commission, session 2. Before we proceed with the business of this afternoon, I'm asking each one of you who may have an electronic device, cell phone, pager, etc., to ensure their silence now. If you don't have an agenda, it's available, including the consent agenda, on the Human Rights Commission website. The consent agenda is a listing of cases in which no written arguments were made to the commission in the allotted time period. The commission has voted on those cases and they'll not be considered further today. The remaining cases on the agenda today are coming before the commission to determine if reasonable grounds exist to believe that unlawful discrimination has occurred. The commissioners have received and reviewed investigators' reports and any written submissions submitted within the allotted time. No new information or any written materials will be accepted today. Cases will be called in order on the accepted agenda. As each case is called, the party who has submitted a written argument will be called to provide the most relevant arguments to the case. The time is limited to 10 minutes. Time may be reserved to rebut opposing arguments, but the time limit of 10 minutes may not be exceeded. Procedural rules of the commission specify that your arguments may address only relevant factual errors, relevant omissions from the report of facts submitted during the investigation, or relevant issues and questions concerning interpretation of the law. The commission allows parties who do not disagree with the investigator's report to rebut comments made by the opposite party. Please be advised that commissioners may ask questions and you will be asked to introduce yourself when it's your turn. Thank you.
Thank you, Commissioner. And I just wanted to remind folks not to use the names of any witnesses or third parties. If we sent you the investigator's report, if there was a witness or third party, we gave them a pseudonym. So please use the pseudonym when you're presenting to the commissioners. And the first case is one that Commissioner Whitworth is recused from. So I will call it, which is H210126 Barbara Dow versus South Portland Housing Authority. And I don't see Miss Dow on here. We are checking the voicemail to make sure there's no message from her. How about if we, while they're checking the voicemail, how about if we take the next case just to be sure? I just like to make sure that there isn't someone who's accidentally not able to access the hearing. And I see that both counsel are here for the second case on the agenda for, does that sound okay if we do that case first? All right, Deb, back to you.
Sure. So E19-0424, Ricky Ho on behalf of Sun v. Charlie's Philly Steakery. This is a reasonable grounds recommendation. So is there anybody here for the respondent?
I believe Sally Morris is here.
Yes, thank you. I'm slow to that mute button sometimes, so I appreciate it. Yes, I'm here on behalf of the respondent, Charlie's Philly Steakery. And I just would like to take a couple of minutes to address the commission in connection with the recommendation in the investigator's report. Based on, I think sort of just based on looking at the.
Oh, hold on, Ms. Morris, are there people seeing that this
and
is
explainants allegations
frozen?
are.
Hold on, Sally.
Do you have, yeah, can you hear me?
So we can now. A second ago, it was very jumbly and garbled, so let's keep trying.
Okay, you know, I could switch to my desktop, which is connected to.
Yeah, you're frozen again.
It's not on Wi-Fi.
I think it might be better for you to switch.
Or should I keep?
We really can't hear you very well, so I think maybe switching is the thing
I'll
to
do that. Yep.
All right, and so in the meantime, while she's doing that, I've now heard from the front office, there are no voice messages from Barbara Dow. So I think the commission, sorry to move you all around, but I think we can safely assume that Ms. Dow is not here, unless, is there anyone else here for Barbara Dow? I don't believe that there is anyone else here for Barbara Dow. Hold on, Sally, we're just calling the first case. So one last call, is anyone else here for Barbara Dow? Not seeing anybody. So typically when the person opposing the recommended finding is not present, the commission votes to adopt the recommended finding. Then generally speaking, we would be looking for a motion. Commissioner Duson?
Yes, I'm sorry to interrupt.
Yes.
I am having occasional loss of audio, and I'm told that when that happens, if I turn off my video, that sometimes that helps. So if you see my screen go off, I'm still here. It's just that I'm trying to address the audio issue.
Okay, thank you for the warning. So commissioners, since Ms. Dow is not present and she's had notice, we would generally be looking for a motion on the recommended finding in the report.
I'll move that there are no reasonable grounds to believe that the respondent discriminated against the complainant on the basis of sex, hostile housing environment, terms and conditions of tenancy, and that the complaint be dismissed in accordance with the act.
Is there a second?
Second. I'll defer to the chair.
No, this
The
is
chair.
Barbara. The chair is recused.
Yes, the chair is recused. She is not participating in
I'm
this.
sorry. I heard another voice say second. And so
Oh, I'm pretty sure it was Deb, but she shouldn't be.
Oh, okay. So I second.
Hey,
She's been bouncing a lot.
Okay, so I'm going to say that Commissioner Ashby is the one who made the motion, and that Commissioner Duson is the one who seconded. And so the motion is to find no reasonable grounds to believe that discrimination happened on the basis of sex. So commissioners, if you agree, you will vote yes. So Commissioner Ashby?
Yes.
Commissioner David? I believe you said yes, but it has to be audible.
Yes.
Thank you.
Yes, sorry.
It's okay, thank you. Commissioner Duson?
Yes.
Commissioner O'Brien?
Yes.
Got to see your hand too. Thank you. Okay, so the vote is 4 votes in favor of no reasonable grounds, 0 votes in favor of another finding, and 1 abstention. So the finding is no reasonable grounds. Okay, so now we can just move on, and Commissioner Whitworth, you're back in the driver's seat.
So we can continue on with
Back to Ricky Ho.
E190424.
Yep.
Okay.
So we were with Charlie's Philly Steakery, and Ms. Morris was about to begin on behalf of respondent.
Hi, yes. Excuse me. Sorry about that. I'm Sally Morris. I am here on behalf of respondent Charlie's Philly Steakery. And our position is that there are no reasonable grounds to support a finding that discrimination occurred in this case. And starting by just looking at the allegations that the complainant made, this is an individual who worked, was a high school student, was looking for a part-time job in the mall food court, and worked only 6 days with the employer, fewer than 40 total hours on the job. And if you look at the allegations that the complainant makes, the statement that is supposedly the basis of the discrimination is a reference to you people. That statement is not tied to any protected class in any way. It's just a statement of you people, which could mean anything, including teenagers who would work at this foodery in the food court. Moreover, as a matter of law, the complainant cannot make out a case for a severe and pervasive hostile work environment based on fewer than 40 hours of work, and the statement relating to you people. If the totality of the allegations that he was called you people while he worked a total of 26.85 hours from August 20th to September 9th. And if you look, I think in the materials, there's text messages between the complainant and the restaurant, the respondent. And this person was given, very willingly given, a lot of time off during the time that he worked for the company. It was a part-time after-school job, and he was given 2 weeks off to go on a family vacation to California, take babysitting jobs, be in Boston for a couple of days, and work around his school schedule. The communication back and forth and the willingness to give him whatever schedule he wanted is completely contrary to a hostile work environment. Moreover, the text messages show that he made no complaints. He was given the time off. He had no problem requesting things, advocating for himself and requesting things he wanted. Could he be paid by a pay card? Who would he be working with? Not once did he say, I'm being treated badly. Somebody's calling me you people. I don't like the way things are going at my employment. Not once. Similarly, he clearly resigned. And when he resigned, he said nothing about discrimination, nothing about being treated badly. He simply said that he wasn't given the hours that he wanted to work on the weekend. And so therefore he quit. He wasn't given the hours that he wanted to work on the weekend after he had only worked for a few days before he went on vacation for a couple of weeks and then came back and worked for another couple of days. This set of facts is what the complainant alleges simply does not rise to the level of treatment based on any kind of protected status, and it does not rise to the level of a severe and pervasive hostile work environment. In the very same text in which he quits, he again advocates himself. I haven't got my paycheck. Where's my paycheck? He did eventually get his paycheck, and he never says, I don't like the way I was treated in any way. And so based on this record alone, there's not sufficient grounds to conclude that there was any violation of the Maine Human Rights Act. And I just want to say a quick word about credibility, because that seems to be a part of the investigators' findings here. This was a business that was not represented by counsel when the materials were submitted. It's a business who the folks who run it themselves fall into a protected class, and there's certainly language barriers in dealing with these folks. It was difficult for them to navigate the process, and in my experience, it wouldn't be the first time that there were one-sided materials in a personnel file, whether there are one-sided notes to the file, unsigned performance evaluations, printed emails about somebody that they never saw. It's a common thing to have in a personnel file. And that's not a sufficient basis alone to conclude that the statute was violated. So based on all of those reasons, there should be a finding that no reasonable grounds exist to believe that discrimination occurred. And I'm happy to answer any questions. Thank you.
Thank you, Ms. Morris. Questions for respondent, Commissioner Whitworth?
Well, I do have a question. So are you suggesting that the absence of information that should be included in a personnel file exonerates the organization from having to provide that information just because it's not there?
No, that's not what I'm saying. What I'm addressing is that the investigators report comments on the fact that there were unsigned performance evaluations produced. What I'm saying that is not an inference of wrongful conduct by the employer, that there may have been unsigned performance evaluations in a personnel file.
Well, what if they're unsigned, then how can you, as the employer, stand behind them and say that they were presented to the employee if they're unsigned? Well,
right, and that's not what I'm addressing. What I'm addressing is the investigators' inference that somehow relates to credibility. I think that a decision can be made here based on the complainant's allegations. There's just not enough here to constitute a violation of the statute. 26.85 hours of work over a period of a month, when there are no complaints made whatsoever about discrimination or being treated badly, when he was clearly advocating for himself, and the statement that was supposedly discriminatory, you people, could apply to anything. There's no reference to a protected status at all.
I believe age in the state of Maine is a protected status regardless of age.
Well, but there's no reference that the language connects to anything. I mean, the allegation in this complaint was national origin discrimination. There's no evidence to connect the statement that was made to anybody.
Well, I understand that, but that was the example that you were given.
Correct. And typically age discrimination applies to people who are over 40.
Commissioner Whitworth is correct that in the state of Maine, it actually covers any age, not 40 and over. It's different than the federal ADEA.
Yes. Thank you.
Your Honor, this is Ricky Ho.
Mr. Ho,
Ricky, you can't speak, Ricky.
Oh, thank you.
It's not your turn to speak at this point, Mr. Ho. So
yes, I apologize.
Okay, so I'm going to keep you muted for now.
Sure, thank you.
So that was Commissioner Whitworth. Commissioner Ashby, questions for respondent?
Yeah, I just, please, I just want to clarify something. I may have just misheard you. Did you say, Attorney Morris, that as a matter of law, the hostile environment claim is not implicated unless an employee works more than 40 hours? Did I understand you to say that?
No. As a matter of law, the claimant has to make out that there was a severe and pervasive course of conduct. There's a lot of case law that talks about isolated incidents and, what are the proper number of incidents that rise to a hostile work environment. My argument here is, given the amount of time that this individual worked and the circumstances around him obtaining time off and that type of thing, there are not sufficient facts alleged that would give rise to a severe and pervasive hostile work environment.
Okay, thank you. I understand that argument. That clarifies.
Just for the record, sorry, Jeff, I didn't mean to interrupt, but for the record, there's been a lot of talk about severe and pervasive, and just so that everyone's on the same page, the standard is severe or pervasive.
Right. Okay. I just misheard you, Attorney Morris. That's all. Thank you.
Yep.
Commissioner David, questions for respondent?
Yes, there's mention of his refusal to wear the hat. Is that part of the uniform, and did other employees wear that hat?
My understanding is the hat is a part of the uniform. I don't have information to answer your question about other employees.
Okay. And you said, I was puzzled when I read it about describing him going on vacation. Vacation, I would have thought would have been for a longer term employee. And you said it was a family trip and he was given permission to do that. I think you also said, and this is the question, did you also say that in addition to taking that two weeks after 26 hours of work, that he also asked for specific hours on weekends?
He asked
how many hours did he work after he came back from the so-called vacation?
I'd have to kind of look that up. I know that he worked a total of 26.85 hours. And that he went on a 2-week vacation. He came back and had a number of conflicts that are reflected in the text messages. He needed time for babysitting and other things. And then he asked for specific hours on a weekend. He was not given them. And so he quit.
So he quit. Okay. Thank you.
Commissioner Doosan, questions for respondent?
Well, I guess I thought I knew what was going on until the last series of questions. So let me just ask the respondent's counsel to confirm the vacation was requested and approved by the business.
Yes, I mean, it's all through text messages. It's a somewhat small business informal, but yes, they allowed him to go and take whatever time he wanted.
Thank you. And in the course of scheduling this part-time after school employee, the text messages reflect back and forth in terms of trying to set the schedule, but the times, I'm not sure how you put it, but the times that he was not scheduled for whatever reason was the result of discussion back and forth between the respondent and the complainant. So you're not alleging that there's any performance issue or concern about complainant's availability to work as a part of that, raising issues about him taking time is what I'm trying to understand what you mean.
Okay.
In terms of taking time to babysit or other reasons for him not being scheduled.
Right. Okay.
Can you help me with that?
Yeah, I understand your question. So my point about the time that he was given off is that it is contrary to the allegation that this was a hostile work environment. When you look at the exchange between the employee and the business about when he wanted time off, nobody was giving him a hard time. They were letting him do what he wanted to do. And he never says anything about discrimination in the back and forth, including when he quit.
May I ask one more question? The behavior that complainant describes as discriminatory occurred while he was on the business premises and is between him and a direct supervisor, not part of the scheduling conversation. I'd like to understand if the scheduling back and forth is with the same employee as the person who said you people. Is that the same person?
I don't believe that it is.
Okay, thank you.
All set, Commissioner Doosan?
Yes, ma'am.
Okay. Commissioner O'Brien, questions for respondent? Oh, you're muted. Still muted. Still muted. Yep, I know you're working on it.
Okay, I think I have it.
You got it.
After all that, I just, right when you began speaking, Attorney Morris, you said something about 40 hours. And I think, Jeff, it may have been in the same vein. Do you remember what you were saying? I thought you said something was not well, do you remember what you started out by saying?
No, but I can tell you that what the point I've been trying to make, and that is that he worked a total of 26.85 hours.
Right.
He did over the course of just shy of a month. So this is an employee who worked fewer than 40 hours with the particular employer. And I make that point in connection with the severe, pervasive, hostile work environment. And that's it.
Okay. Okay. I'm set. Thank you.
And I'm just gonna echo something that council said before to remind folks the correct standard is severe or pervasive. So at this point, we will turn to complainant. Ms. Morris, you'll have 5 minutes left for rebuttal after we hear from complainant. So that would be Mr. Levine, I believe.
Yes, it is. Thank you.
Can you hold on, Mr.
Sure.
Levine? Yes, Ms. Morris.
Yeah, I just have a procedural question. I believe there wasn't anything submitted within the deadline by complainant. So
our procedural rule provides that the person who supports the finding is allowed to respond to comments made by the person who opposes the party opposing it. So he's perfectly within his rights to present.
Great, thank you.
Thank you, everyone. So just as a matter of stating the exact facts of this case, he actually worked a total of about 33 hours. He came back to work on 10/5 and 10/6 and worked 5.93 hours. On 10/12 is when he told him he didn't want to work there anymore, and he came back for his check, and he got paid for one check for the month before, starting August 26th through September 7th. He got paid $165, and then he had to come back 2 days later to get the rest of his pay for 10/5 and 10/6. And he did say in a text message, when I asked, can I come in to pick up my check time and again, the manager, who's different than the owner, deferred and most recently told me to contact so-and-so. I don't even know who they are. I worked and earned approximately 23 hours, which I should get paid for instead of chasing him around. You can tell in that text message he's somewhat frustrated. He's a 15-year-old boy, an honor student at Gorham High School. This was his first job, and it was a job from hell. He dealt with a manager who, over the course of 33 hours of work, approximately 30 times referred to him as you people. He slapped his hand when he didn't operate the cash register properly. When customers tried to give him a tip, the manager took his tip. When friends of his came into the mall who were girls who also went to high school with him, he made lewd comments about those girls and said, "Don't tell my wife that I said that." And then he submitted on his behalf various affidavits in support of his position, one of which was from a coworker. The coworker was actually his wife. She did not identify herself as his wife. She simply stated where she lived. His affidavit did not state where he lived. So there was no connection between them other than manager and coworker, when in fact, manager and coworker were married. And so there's one line in the investigator's report that I think is essential to understanding this case. He says on page 4, Sun's version of events was consistent and credible. Being called you people 30 times over approximately 33 hours is pervasive conduct. What's also interesting is that the performance reports that were submitted on behalf of the employer were signed by the manager and not by my client. And my client denied he ever saw those reports. And there is no signature on those reports. And it makes absolutely no sense that he wouldn't have seen them if they're criticizing his performance. This was pervasive. This was severe. This went on long enough. And my client, who's a 15-year-old boy who's trying to process what is happening to him at this job that he hoped would be, a good experience in the mall, is talking to his parents, one of whom wrote an affidavit supporting that he complained about the manager, supporting that he, the father, talked to the manager and said, you can't say things like that in the United States. All of those things were credible and consistent, whereas the employer's response was not credible, not consistent, and really simply made no sense. So I I support, or I ask you to support, the investigator's finding of reasonable cause.
Thank you, Mr. Levine. I would just note for commissioners that I believe the information Mr. Levine offered about a tip being rejected, I believe that that was not provided previously to the investigator.
I actually think it's in the record.
Okay, thank you. I stand corrected. So questions for complainant. Commissioner Whitworth.
No questions, thank you.
Commissioner Ashby.
No questions, thank you.
Commissioner David.
No.
Commissioner Dusan.
No.
Commissioner O'Brien.
No.
Okay. So Mr. Levine, you'll have about 6.5 minutes left after we go back to Ms. Morris. Okay, Ms. Morris, you have about 5 minutes left.
I don't have anything further. Thank you.
Oh, okay, that was fast. Mr. Levine, you have 6.5 minutes.
And I don't have anything further. Thank you.
Brilliant. Okay, thank you very much. So then we turn to the investigator. This is a case where Milo Gitchos did the investigation and it's being presented by Bob Beauchene.
Thank you again, commissioners. Good afternoon. As noted by the investigator in the report, as well as noted by respondent's attorney, in this case, parties provided two very different descriptions of complainant's work experience. Some contended that the manager repeatedly used the phrase "you people" when correcting him for work errors in front of customers, and the manager once grabbed his arm and slapped his hand while correcting his behavior. Respondent denied that any of the above occurred and claimed that Sun was discourteous to customers, failed to follow directions from manager, and failed to comply with respondent's dress code. Given the disparity of the facts in this case, the investigator indicated that, again, it really came down to a credibility assessment. In making that determination, the investigator noted again that while C's versions of complainant's version was found to be consistent and credible, the information provided by respondent was not, and he cited to a few specific reasons. Number one, respondent asserted that Sun was absent from work from 9/9 until 9/22 in one of respondent's submissions, quote, without any prior notice to respondent or even an explanation for his absence after he returned to work. Complainant specifically claimed that he informed the manager at least 1 week beforehand that he would be taking a family vacation on those dates. Despite respondent's claim that they had no notice, you will see both in respondent's submission and opposition to the report that it's clear that complainant asked for and received vacation time, belying any claim that the respondent had no idea where he was for that span of time. I believe it's also fair to believe that had complainant simply been absent from work for that length of a period of time without providing any word to his employer, especially as a new employee, in all likelihood, his employment would have been terminated. So that was certainly one inconsistency as far as whether or not the vacation time was requested beforehand or whether he simply was absent from work without notice, which is what respondent initially claimed. Number two, the investigator also noted questioning the affidavit from manager's wife. While respondent is correct that that relationship in and of itself wouldn't necessarily suggest that the information was not accurate, in this case, the fact that both the manager and the affiant had different last names, as well as no reference whatsoever in the affidavit that the two individuals were related, suggests that respondent may have been attempting to convince the commission that the affiant was simply a objective observer and not the spouse of the individual who was in fact accused of the discriminatory conduct. Lastly, the investigators noted in the report also had issues with the alleged performance evaluations that were submitted. Respondent claimed these to be credible appraisals of complainant's work. But again, in this case, the fact that the evaluations were not signed or even shown to him, as respondent conceded in another one of its submission by noting, as complainant was in a grace period and the employment relationship was at will, respondent had no obligation to share and get the signature of complainant and the job performance evaluations. This led the investigator to conclude that the evaluations were either produced after the fact solely to support respondent's claim before the commission, or in the alternative, that he was being evaluated in a manner that was never happened with any other employee. Respondent offered no evidence that there were other employees who received weekly secret evaluations during their first 3 weeks of employment, again, calling into question whether or not they were an accurate representation of his work performance. And addressing just a couple of claims made by respondent's attorney here today, while it is certainly possible that the phrase "you people" could refer to just about anything, I think it would be most likely a reference to a complainant's race and national origin in this case. Although respondent's attorney suggested that it could have been a reference to his teenage status, there is nothing in the record to show that any other teenage employee that may have worked there was ever referred to by the phrase "you people." And again, as noted by complainant's attorney, if complainant's credibility is found to be superior in this case, he did state that he was called that approximately 30 times over the period of 33 hours, certainly seeming to satisfy the prong of pervasive. With respect to the wearing of the hat, I would note again that this was a credibility issue as well. Complainant, in fact, noted that after initial hesitation to wearing the hat, because he was concerned about an allergic reaction on his scalp because the hat was apparently dirty, again, respondent claimed that he continually refused to wear it. So again, if the investigator had to come down on one side or the other where there was this type of a dispute, based upon the issues I mentioned earlier, it seems reasonable that he gave more credence to complainant's claim than to respondent's in that regard. Lastly, with respect to the complainant not filing any type of formal complaint, again, there was really no way to verify the conversations that father or the son may have had with the respondent about the use of the phrase "you people." But even assuming the complainant did not say anything specific in his resignation or afterwards with respect to the discrimination, that's not necessarily that unusual, especially for a very inexperienced employee who might fear that firing a gunshot as far as making a complaint when walking out the door could doom his chances with prospective employers as well, worrying that he might receive a poorer reference if he was found to be a disgruntled employee or made complaints while he was walking out the door. So again, in this case, it really came down to with all due deference to respondent not having counsel throughout the process, they're still nevertheless bound by assertions that they make in their submissions. And in this case, where there were at least a couple of instances where what respondent was claiming was simply not borne out by the record. And in that particular kind of case, the investigator found that if he had to give more credence to one side or the other, the respondent was inconsistent in a number of instances, whereas there were no such discrepancies in complainant submissions.
Thank you, Bob. Commissioner questions for Mr. Beauchene. Commissioner Whitworth.
No questions.
Commissioner Ashby.
No, thank you, Bob.
Commissioner David.
No.
Commissioner Duson.
I have no questions.
Commissioner O'Brien.
All set.
Thank you, Mr. Beauchene. So commissioners, you've heard from the parties and the investigator. So at this point, we need a motion.
I'll move
Oh, okay.
to accept the recommendations of the investigator. that there are no reasonable grounds to believe that Charlie's.
Nope, this is a reasonable grounds recommendation.
Sorry. Bad eyes. That there are reasonable grounds to believe that Charlie's Philly Steakery discriminated against Ricky Ho on behalf of his son based on race, national origin, and/or ancestry, and the complaint should be conciliated according with the act.
Second.
So just to confirm, Deb, it was your intent to make a motion to find reasonable grounds?
Yes.
Okay.
Yes, thank you.
Okay, so it's been moved and it's been seconded. Is there any discussion among commissioners?
I just wanted to say that I was troubled by this case as I was reading it. I was troubled by whether or not it was meeting in the 26 hours of employment, the standard, which seems quite high, that it requires objectively hostile or abusive environment. And it didn't seem to me, coupled with the 2 weeks off for the family vacation, that we really know that at that point. And I just wanted to say that I am persuaded to go along and vote in favor because of Bob's presentation, which focuses me on the repetitiveness on it, the inconsistency in respondent, the suggestions that are unrebutted about manipulation by respondent, suggesting an attempt to cover up and an understanding that they had crossed the line here. So I'm going to vote in favor of the motion.
Any other discussion between Commissioner Dusan?
Yeah, I listened carefully to respondents' argument that this because of the number of hours that the complainant was present at the workplace, that this behavior could not be pervasive, or the other word, I'm getting
severe.
Thank
severe
you.
Or pervasive.
But I'm convinced that if the even just the words that the complainant alleges were used 30 times in something plus or minus 30 hours, at the very least, the language was used once an hour, and it seems that it probably was bunched together. I don't know that for a fact, but at the very least, it was once an hour. And I am convinced by the investigator's report that the complainant has certainly met the reasonable ground standard of the commission, which is that there is at least an even chance that the complainant would prevail in a civil action.
Any other discussion for commissioners? Commissioner O'Brien?
Yes, I just wanted to say I am troubled also. As Commissioner David said, I haven't gotten over the hump yet, so I'm going to be voting no on this.
Any other sorry, Commissioner. Okay. Any other discussion among commissioners? Seeing none. Okay, so the motion is to find reasonable grounds to believe that Charlie's Philly Steakery discriminated against Ricky Ho on behalf of son based on race, national origin, and/or ancestries. And if you vote yes, you are agreeing with that. So Commissioner Whitworth?
Yes.
Commissioner Ashby?
Yes.
Commissioner David?
Yes.
Commissioner Dusan?
Yes.
Commissioner O'Brien?
No.
Okay, so the motion passes. The finding is reasonable grounds. And the commission will send correspondence to parties and council reflecting the finding and outlining the next steps in the case. And thank you to Mr. Levine and Ms. Morris and Mr. Ho for being here, but we are finished with this hearing and moving on to the next one. You're welcome to stay on the call.
Thank you. Thank you much.
That's you, Deb.
Our next case is a housing case, H21-0127AB. Reasonable grounds recommendation. Warren Malcolm, the apartments at Brunswick Landing and Main Properties. Is there anybody here for the respondent?
I believe Alyssa Tibbetts is. So Ms. Tibbetts, you have 10 minutes.
Thank you. This case involves a complainant who applied to rent an apartment in Brunswick that is owned by Respondent Apartments at Brunswick Landing and managed by Respondent Main Properties. Main Properties manages over 1,200 rental units throughout southern Maine, and in order to process a high volume of applications for those units in an efficient and consistent manner, Main Properties utilizes a platform developed by a third-party company called Yardi, which offers software designed to assist with property management functions, including leasing functions, applications, and the performance of credit and background checks. In this case, complainant submitted an application for an apartment through Main Properties website on or about March 29th of 2021. The unit complainant sought was listed with a monthly rent of $15.95 per month, with tenancy to begin on September 1st of 2021. Main Properties requires, as part of its standard rental criteria, that for all of its units, an applicant's gross monthly income from any verifiable source must be at least 2.5 times the monthly rent for the apartment applied for. Further, applicants must provide documentation to support all claims of verifiable income throughout the duration of a requested lease. This means that in this case, complainant was required to submit proof of verifiable income totaling at least $3,987.50 per month. The complainant listed on his application a monthly income of $4,000, as well as additional income from $500 in the amount of $500 from stocks. In support of that, complainant submitted documentation of $681.77 to be received or had been received effective December 1st of 2020 in service-connected disability compensation. And complainant also submitted screenshots of a bank account showing current unemployment insurance income totaling approximately $2,980. However, complainant did not provide any official verification or documentation of continued eligibility for those benefits, which were publicly known to be ending effective in the fall of 2021. Complainant also submitted screenshots showing the current balance of his personal stock account. However, screenshots from a computer or mobile device are not considered verification for purposes of satisfying the standard rental criteria. And generally speaking, the value of stock account is not considered a verifiable source of income. So therefore, complainant provided proper documentation of only $681.77 of monthly income, far less than the required $3,987 of required income to rent the apartment. As a result, Main Properties determined that complainant had not provided sufficient verification of the minimum amount of income needed to rent the unit for which he'd applied and denied the application. Main Properties issued a letter to the complainant the day after his application was submitted, stating that his application had been denied due to, quote, insufficient income to support rent. Following the issuance of this letter, a leasing agent from Main Properties called complainant to discuss the denial. Complainant recorded the phone conversation and submitted that to the commission as part of this investigation. And the majority of that nearly 6-minute recording is hardly audible. However, it can be heard from the recording that the leasing agent begins the conversation by explaining to complainant that Main Properties could not approve his application for housing because he did not provide sufficient sources of verifiable income. They then go on to discuss the sources of income and the documentation provided and why the same were considered inadequate. Only after that conversation does the leasing agent go on to note to complainant that he listed a co-applicant and did not provide a social security number for the co-applicant. She explained that in order to approve the application, she would also need a social security number for all applicants in order to complete credit and background checks. The investigator's report stated that this recording contradicted Main Properties' position that complainant's lack of verifiable income was the basis of their denial of his application, and concluded that even if complainant had provided the requisite proof of income, Main Properties would not have rented to him because he had not provided a social security number for his co-applicant. It is true that Maine Properties requires a social security number for all applicants and cannot approve an application for housing without one. The reason for this is because Maine Properties performs a credit check and background check on all applicants for housing, and it does not have the capability through its Yardi software to perform those checks without a social security number. In the rental housing industry, the requirement of a background and credit check is an extremely common and necessary legitimate business practice. This issue was raised with complainant in order to assist him in making an application in the future, not to deny him housing. However, the clear fact is that the primary basis for the denial of his application was that he did not satisfy the income requirements for the apartment that he sought. The investigator's conclusion was that Maine Properties would not have rented the apartment to complainant even if he had met the income requirements, and this therefore constituted reasonable grounds to believe that Maine Properties discriminated against complainant on the basis of his wife's lack of a social security number. This conclusion is based on a statement asserted by complainant that was not supported by any further evidence. In particular, the complainant asserted that he and his wife had applied for another apartment in Indiana through it that also used the Yardi software called Rent Cafe, and that their application had been approved without her social security number. However, complainant only provided a screenshot from the Rent Cafe portal showing only his name connected with the approval for this apartment. There were no records submitted by complainant during the course of the investigation to demonstrate that his wife was listed as a co-applicant. Further, there was no information provided regarding the requirements for application or tenancy at the apartment complex in Indiana, or that complainant's application was approved there without a social security number for all applicants. Nevertheless, the investigator's report concluded that, quote, complainant then applies for his current apartment through platform with wife as a co-applicant for which a background check was run by application. Complainant and wife were approved for that apartment, end quote. The Rent Cafe screenshot provided by complainant is not only insufficient to support the conclusion in the investigator's report, it is also—
Ms. Tibbetts, I'm sorry to interrupt you, but the investigator did just let me know the names of these third-party sites those are actually third parties, and if you could not use their names, we did not use them in the report, and I'm sorry I didn't catch that earlier. Thanks.
I apologize. I'm sorry I didn't catch that either. I will not do so going forward.
Yeah, sorry to interrupt you. Go ahead.
No problem. Thank you. The screenshot that was provided was not only insufficient to support the conclusion in the investigator's report, it is perhaps more importantly insufficient to meet the legal standard necessary to prevail on this claim. This case involves a claim of a disparate impact in a housing policy on the basis of the applicant's association with someone whose national origin is other than that of a United States citizen. That is Maine Properties policy and practice of requiring social security numbers on applications for the purpose of performing credit and background checks on potential tenants. A disparate impact would mean that this is a facially neutral policy and practice, but has the potential to disparately impact individuals who do not have social security numbers. Once a prima facie case of disparate impact resulting from a housing practice or policy is established, the respondent must demonstrate that the policy or practice is necessary to achieve a valid and legitimate business interest. Here, the valid and legitimate business interest is that of performing credit checks and background checks of potential tenants for rental housing. Requiring a social security number of every applicant is ancillary to that purpose. There can be no dispute that requiring background and credit checks of potential tenants is a legitimate business interest and necessity for both Maine Properties and all of its tenants. However, the investigator's report stated that respondents did not establish that this practice was a business necessity. While we disagree with that conclusion, what's perhaps more concerning is that the report also concluded that respondents did not establish that a less discriminatory alternative was available because of the fact that complainant and his wife successfully applied for and obtained apartment elsewhere through the same software platform. We not only disagree with that conclusion and believe that it is not supported by the facts or evidence presented throughout this investigation, we believe that it misapplies the legal standard for this type of complaint. In the case of a complaint of disparate impact, once a prima facie case is established and the respondent demonstrates a legitimate business necessity, it is then the complainant's burden to prove that a less discriminatory alternative was available, not respondents. In this case, complainant did not prove that a less discriminatory alternative was available. He simply made an assertion that he and his wife were approved for housing elsewhere and provided a screenshot showing only his name as the applicant and a check mark next to that application. This evidence on its own does not satisfy complainant's burden of establishing that there is an available and adequate alternative to Maine Properties for the purpose of serving its legitimate business interest in conducting credit and background checks on applicants for housing. And finally, this conclusion and focus on the fact that Maine Properties requires a social security number of applicants to serve its legitimate business interest entirely ignores the established fact that complainant's application for housing was denied because he failed to provide proof of sufficient income to rent the unit for which he applied. Thank you.
Thank you, Ms. Tibbetts. Questions for, just to be clear, Ms. Tibbetts, you represent both respondents?
I do, thank you.
Okay, yeah. Questions for respondents, Commissioner Whitworth?
No questions, thank you.
Commissioner Ashby?
Yes, Attorney Tibbetts, you've convinced me of the generalized legitimate business interest in securing social security numbers from people you need to do background checks. But do you have a legitimate business interest, a specific legitimate business interest in securing social security numbers of people that don't have social security numbers? Meaning, I'm being facetious here, but meaning, is it your expectation that people in the complainant's wife's position are to go out, secure a social security number as a result of their new arrival into our country, and then somehow that number would have any business benefit to you to know? Because that number wouldn't be tied to anything, would it?
No, you're correct in that our argument is that the legitimate business interest here is solely the ability to perform a credit and or a background check of an applicant. The social security number is the mechanism by which, the only mechanism by which respondents in this case were able to do so. So to the extent that there is an available or adequate remedy, Maine Properties was not aware of it and did not have access to it. And in this case, what's most important to understand is that the burden of proof in terms of the legal standard for this type of claim rests with the complainant to demonstrate that there was in fact an available or adequate alternative to a social security number to meet the purpose of the legitimate business interest of performing a credit or a background check.
Sure, but if the burden shifts to the complainant and the complainant says that there is no social security number, I mean, what other, how else could the complainant meet that burden? I mean, you're asking for a social security number that even if you got it, wouldn't have any benefit to you.
Well, I guess I disagree that it wouldn't have any benefit. I mean, it is in fact the only way for Maine Properties, at least, and I can't speak for any other housing management providers or owners, to perform a credit or a background check. And so they don't have an interest in having a social security number, but for that purpose solely. And if it is not their legal burden to prove that there is an available and adequate remedy, and they do not have an alternative to performing or serving this legitimate business interest absent a social security number, that is in fact the legal standard.
Well, I don't want to sound argumentative, but I hear you saying then that we can never rent to people that don't have social security numbers. I mean, that's what I hear you saying. And I think that's exactly what the gravamen of the complainant's complaint is, at least as to the disparate impact claim. And I hear you almost conceding it, that in light of this situation, we can never rent to people who don't have social security numbers.
Well, I take a narrower view of this. While I understand the larger impact of this case, I'm making an argument on behalf of the facts in front of us with respect to this complainant and this property management company as a respondent and the legal standard as it exists today. So I'm being careful here not to insert any sort of personal opinion or editorial comment in response to your question, because it's a much broader question as I view it in the context of this case. From a very narrow perspective, I'm representing a respondent and I'm putting forth an argument to you about the legal standard as it exists today in terms of a legitimate business interest and a burden shifting framework with respect to the requirement to establish that there's an alternative that is available and adequate. I don't want to answer your question by talking about whether there should be an available or adequate alternative to that, because the facts of this case are that there are not.
Well, changing gears just slightly, didn't the complainant say to you folks, at least in argument, and maybe it was only at the investigation level, I don't know, but didn't the complainant say, look, my wife has passed 2 background checks already as a result of her needing to come to the United States? Isn't that an implied suggestion that that's an alternative available to you to rely upon in your need to have a person with a good background?
So my recollection of the manner in which and the timing of which that information was submitted was that it was during the course of the investigation. There's no evidence that that was stated to the leasing agent or to Main Properties when it was evaluating complainant's application. That discussion occurred after the fact in the context of this complaint to state after the complainant was denied housing with Main Properties that he then went on to apply for housing elsewhere and was approved. However, outside of complainant's assertion that that occurred, there's no evidence that's been provided that that application in fact included his wife as a co-applicant, that a background check was performed, that a credit check was performed, or how that was done in the absence of a social security number. It's also noteworthy that during the one conversation that took place between complainant and the leasing agent, complainant stated, my wife's applied for a social security number, we should have that. It's possible that a social security number was provided to a subsequent leasing agency. However, none of that information was submitted in the context of the investigation. So it wasn't a reference point for Main Properties in considering the application because it wasn't raised until this investigation.
Fair enough, thank you.
Commissioner David. Yep.
Do you know that Main Properties asked whether there was anything that would substitute for a social security number? It sounds to me like you're saying, in the same vein that Commissioner Ashby was asking you, that you're just saying that because the software wants it and it wasn't there, therefore the application was denied. But the record indicates that there were 2 background checks, and a visa, which requires vetting. And you're saying that those would not substitute, or they didn't know about it until after the investigation?
The subsequent background checks and visa were not provided to Main Properties at the time of the application that was denied by respondents. Those were discussed.
Did they ask? Did they ask? Did they say, why is there no social security number? And we're told that this is a recent person coming to our shores and has been through other procedures that because they don't have a social security number because they're an immigrant. It just seems like a triumph of a bureaucratic procedure over a substantive one to be clear about whether there's a criminal record or not.
The only conversation that we have available or in the evidence and that I'm aware of occurred between the leasing agent and the complainant and was provided in the phone recording that was submitted, in which the leasing agent notes to complainant that this was a hurdle in their application process and that she did not have the capability to perform these checks, which are a standard requirement of their rental criteria, without that. The complainant responded.
I think I hear your response. I think I missed initially you said that the proof of the $3,987 a month was not sufficient because it was that stimulus money or something that had no indication that it was repeatable. Is that what you were saying?
Yes, there was only $681 of the nearly $4,000 that's required that was documented in terms of ongoing benefits. Almost $3,000 of that consisted of unemployment insurance. A large bulk of that was stimulus funded, which was slated to end in September, and the lease was slated to begin in September. There was no ongoing verifiable income.
Last question. Is it a requirement that husband and wife be co-applicants?
No, it's not.
So he wouldn't have had this problem if he hadn't put his wife on the application? and discovered that she didn't have a social security number?
Well, that's not
Or
entirely.
I'm sorry, yeah. Or the denial would only be on the basis of the income question, not on the social security.
So I'll reiterate, the main property's position is that the denial was solely on the basis of the income. The denial was issued based on the lack of income. The discussion about the social security number was raised in the context of assisting complainant to make application in the future, not to deny him housing. It was not the basis of denial. The complainant submitted an application showing only his income. He listed a co-applicant with no income, and so the application was denied on the basis of the lack of income and would have been in any event.
Thank you.
Commissioner Dusan, questions?
So I'm just not sure I understood a clear answer to, given all the foregoing conversation, do I hear a conclusion or a position that the respondent would not rent to someone without a social security number, whether they don't have one because they are newly to the country, or they don't have one because they've been here all their lives, but they haven't been in the social security system?
No, so during the course of the Issues and Resolutions Conference, respondent stated to the investigator that it had undertaken research with the software program provider to determine if there were alternatives available to perform the background checks or credit checks of potential applicants without a social security number. At the time of this application, that was not available to them. However, when the issue was raised, they subsequently looked into it to determine if there was, in fact, an alternative. However, that was not the basis of the denial of the application.
There's this agency that's performing the background checks is doing so pursuant to a contract with the respondent for a fee?
Correct.
And the means by which they fulfill that contract is using this software service. So, and your argument is that there's no other way to check on criminal history or financial information. There's no way other than using this software service, as far as your client is aware.
At the time that this application was submitted and ultimately denied for lack of income, the subsequent conversation with the leasing agent was raised with the complainant because they did not have any capability at that time to perform the necessary checks to proceed with an application in the event he did provide proof of verifiable income.
Interesting. Okay, thank you very much. I'll have another question for Corporation Counsel. So, Counsel, thank you very much.
Commissioner O'Brien, questions for respondent?
All set, thanks.
Okay, thank you, Ms. Tibbetts. You only have about 30 seconds left after we hear from complainant. Mr. Malcolm, I believe I saw you on here.
Yes, can you hear me?
Yes, we can. So you'll have 10 minutes and go ahead.
There's a lot to take in, but I'll try to keep myself composed here and stay on track. Just a little background. My wife and I, we entered the United States on February 7th. Initially, we went to Arizona. It was a long fought battle because of COVID. They had actually delayed her visa because the country was, shut down and whatnot. But regardless, she had to go through multiple checks this again because of the COVID, because time had expired. So she went through multiple agency checks. I'm not privy to all immigration, what requirements there, but I know the National Visa Center, the Homeland Security does their thing. I'm sure there's others as well. So, I mean, I can't see how she would have even entered the country without passing those kind of checks. And I'm sure those agencies do much more stringent checks than any apartment complex could. In the meantime, I know this wasn't submitted at the time, and it's because I did not have access to, I had done as a co-application with my sister in Arizona. We had initially planned to move down there, things happened, but we all three of us had applied for an apartment and she was approved without a social security number. But I'm not sure, I'm just saying there's other, using the same platform.
Mr. Malcolm,
Okay.
you're not allowed
Okay.
to talk about things
Okay.
that aren't in the record.
Roger that. But responding to, I think Attorney Tibbetts had said that I could have applied for the property myself without listing my wife as a co-applicant. As far as any lease that I've ever read and signed, anyone over the age of 18 must be on the lease. I've never seen it otherwise. And each apartment complex has different rules on how long someone over the age of 18 can stay without being part of the lease. And I believe on Yardi, or the website, sorry for using third name, that it does ask that anyone over the age of 18 be part of the application. I may be remembering incorrectly. I have not looked at it at some time, but there's one reason. Another reason is, for our green card interview, we have to be able to provide evidence that our relationship is bona fide, it's real. So, and one of the recommendations from the agency and also our immigration lawyer is to try to have things in both of our names.
Mr. Malcolm,
yeah.
I don't think that information is in the record. Was that previously? Yeah.
Sorry. Not attorney, I'm just trying to give context. As far as the income, I believe I had spoken with another leasing agent the day prior before my application, trying to explain the situation, what I have and don't have as far as income. I wasn't told anything wasn't necessarily, doesn't count. So I believe on the website, Main Properties Brunswick Landing, it says job offer can also constitute as proof of future income as well, or a current job. I had currently unemployment at the time, but there's nothing to say a job offer wouldn't fall through, or someone might lose their job from the time I had made the application to when the lease, the apartment would become available. So to me, it's kind of odd. The apartments are available for application in March when they're not due till September. A lot can happen in 6 months, and you can be approved and future income might be gone if somebody loses a job. So I don't have much else to say. I guess strictly, I guess, for the record, but I'll end there. Thank you for your time.
Thank you. Questions for Mr. Malcolm? Commissioner Whitworth?
No questions.
Commissioner Ashby?
I have no questions. Thank you.
Commissioner David?
Yeah, did you have the capability financially to offer the entire year's rent?
I do, sir, many times over. I have worked in contracting for years overseas and saved up a very good chunk of change. I'm still currently not working. I'm deploying in a couple of weeks, but I do have sufficient means. Yeah, so I do have, sorry. I have
to stick to what's in the record.
Yeah, and that was in the record that you made that offer, and you're saying that you had the assets to do that. My question is, were those assets disclosed on the application? I disclosed
what I needed to meet the minimum threshold. I don't remember if I disclosed all my assets. I may have. I think I disclosed the balance of my stock account. I don't think I did my entire savings and checking account, though. I just did what was necessary. It may have been part of the screenshot showing the unemployment income as a steady income. It might have had my entire checking balance at the top at the time.
Did you have, last question, did you have offers of employment that you disclosed?
At the time, no, because what I do takes time. Okay. And I moved back there for family, but yeah, I had a job after I left the Maine, so I turned it down because I had already left.
Okay, thank you.
Yes, sir.
Commissioner Duson, questions for complainant?
No, I don't have any questions.
Commissioner O'Brien?
Thank you. No.
Okay. Mr. Malcolm, you have just over 6 minutes left when we come back to you.
Yes, ma'am.
Yep. Now we go back to Ms. Tibbetts. Ms. Tibbetts, you have about 30 seconds left.
I'd just like to reiterate that our position is based on the facts of this case before you today, not the larger policy discussion of housing applications generally. In the context of the facts that were presented in the investigation and the legal standard as it exists today, as I outlined in my prior presentation. Thank you.
Thank you. Any follow-up questions for Ms. Tibbetts? Commissioners, if you have one, raise your hand. Seeing none. I like this method. Mr. Malcolm, you do have 6.5 minutes left. If you want to use them, you're welcome to.
Just one last thing, I guess, is they made the, I guess, you need to have a social security number to be able to rent, and there's no alternative. Other alternatives have existed in places I've been. I won't get into that. I know it's not, but it made it sound like it was extremely easy to go out and get a social, like, you know, you can go get one within, you know, a week or so. You know, it was a time-consuming process due to COVID, and I had to fight with the SSA in multiple locations to try and figure out what happened. I did get it eventually, but it's not like something that happens overnight. So, you know, Maine Properties said they had 1,200 properties. I believe it was in Southern Maine. That already discludes us from those 1,200 properties, and Maine already, you know, for us anyways, it's very difficult to find a place to live due to lack of housing. So that's all I have to say. Once again, thank you for your time.
Thank you. Commissioners, any commissioners with a follow-up question for Mr. Malcolm, raise your hand. Seeing none. Oh, this is so much better. I'm going to do it this way from now on. Okay. Thank you, Mr. Malcolm and Ms. Tibbetts. So now we're going to mute you both and turn to the investigator, Investigator Thompson-Crossman.
Good afternoon, everyone. My name is Kit Thompson-Crossman. I was the investigator assigned to this case. I just want to clarify a few things. The phone call, I will admit the quality is not great, but I listened to it several times and I was able to discern most of what was said. It does start with a brief discussion of complainant's income. The leasing agent who's speaking to him then sort of breaks off and starts talking about the fact that she can't process his application because his then fiance, now wife, didn't have a social security number. And they go back and forth about that a few times, and complainant explains that she's new to the country and they haven't been able to get a social security number yet. And the leasing agent basically says then what she also said to me at the Issues and Resolution Conference, which is, I can't process an application if I don't have a social security number. There's no other way for me to do the criminal checks or the credit checks that I need to do. And then goes on to ask complainant some more questions about his income. And at the end of that conversation basically says, well, you don't have sufficient income that's verifiable to rent here anyway. But the first thing that gets said to him about why he's not going to be able to get the apartment is that his wife doesn't have a social security number and she can't process the application because of that. I just wanted to clarify because I think we've heard a couple of different things about that. And it wasn't first your income doesn't work, then, oh, by the way, if you get proof of income and your wife gets a social, then we can approve your application. It was, your wife doesn't have a social, I can't process your application. If you get a social and then you can show me sufficient income, then we can move forward. And I think he says, you know, if you can get the social in like 30 days, we can review this again. You don't have to submit a new application. But as Mr. Malcolm said and said to me at the Issues and Resolution Conference, that was a time-consuming process. And at the time of the IRC, his wife still didn't have a social security number. And that was 3 months, I think, after he'd filed the complaint almost. The leasing agent did say that they had called Indiana to see how the Indiana property was using the software, to see how that was set up. It wasn't totally clear But it seemed from that conversation that it was sort of understood that the Indiana housing complex had a different way of processing applications that did not require a social security number to approve them. And that's borne out by the fact that complainant did in fact apply with his wife as a co-applicant to those apartments and was approved for them through the same software. It is in the record that his wife went through multiple criminal background checks done by at least one, probably more than one federal agency, which did not obviously require her to have a social security number. And so there were methods available to verify that information without her social security number. Their criminal background checks don't always require a social security number. And Commissioner David, your question about whether he had the assets to pay the full year's amount, he did ask the leasing agent in that phone call if he could just pay the whole year's amount. So while I don't think he disclosed his full assets, he did ask that question, indicating that he had the amount to pay, and she said, no, the company doesn't do that, basically. Yeah, okay. I think that's all I wanted to clarify. I'm happy to answer any of your questions.
Thank you, Kit. Commissioner questions for the investigator. Commissioner Whitworth?
Yeah, I do have a question or two, maybe a comment. I'm not sure if it's different in employment than it is with housing, but every criminal background check that I conduct through different background check organizations, every single one of them requires a social security number in order to do the background check. And I don't know that I would have an alternative to a social security number.
Those alternatives, other than the criminal background checks that Mr. Malcolm's wife had already gone through, aren't in the record, so I can't probably comment directly on that. Just that she had already undergone criminal background checks as part of her immigration process without a social security number. And there is some evidence in the record that the Indiana property was able to process their application without her social security number, although I don't know if they were also doing criminal background checks. I know they were doing credit checks.
Okay. Okay, thank you.
Sure.
Just a second, Commissioner Duson, I find myself for some reason continuing to go through because I can't seem to help myself. Commissioner Ashby, questions for the investigator?
No, thank you.
Okay, Commissioner
I have a
David?
question for the-
Yeah.
No.
Okay,
No.
Commissioner Duson, I'm sorry. I keep going back and forth between different methods of
It's
asking
okay.
for questions.
It's okay. And in the midst of that, the audio went out again, so I wasn't sure if I missed my chance to ask a question.
No, this is it.
I'm looking for help because I have the impression that you're not supposed to inquire about the national origin of a potential tenant. And it seems that requiring a social security number as a prerequisite to considering an applicant, it may be around the back door, but it seems like it in effect is inquiring about national origin. And so I wanted some help with that, from the investigator.
Sure. I think probably as a percentage of people who don't have social security numbers, folks who were born outside of the United States are probably make up a majority of that. I think there are US citizens who don't have social security numbers for whatever reason, folks whose parents don't want them to be part of the system in some way. But I do think that the majority of folks who don't have social security numbers were born outside of the US.
So requiring a social security number seems like an inquiry about national origin. So I'm kind of stuck there. It's kind of like, so I haven't looked, it's been a while since I looked at the guidance from the commission on what can be on an application for housing. But I'm vaguely recalling that there are other inquiries that the advice is that they should not be on an application because of the risk of disparate impact. And I'm trying to distinguish why this would not be there, why this would not be such a item.
Well, and maybe Barbara can answer that more fully, but I think that the recommendation in the report is basically that asking for a social security number does have a disparate impact on folks whose national origin is other than US citizen. And so whether or not that was intentional, it does have the disparate impact that people who are not US citizens are going to have a much more difficult, if not impossible, time applying for housing with respondents.
Yes, I am convinced by your report and your investigation and your recommendation. I was just trying to keep my mind open to understanding it from a different angle.
Barbara maybe has.
I can jump in, although I don't have really much more to add beyond what Kit has said. I will say we didn't consider this an unlawful inquiry case because when we do that, we look for a direct question like fill in your national origin here or identify your date of birth, attach a picture to your application.
Right. That's what I'm vaguely remembering. Right.
Right, which is not what happened here. I think that the effect turns out to be less than neutral, but I think that on its face, it is not a prohibited inquiry.
Okay, thank you.
Commissioner O'Brien, any questions for the investigator? No. Okay, thank you. Thank you, Kit. So then at this point, we've heard from the parties and the investigators. So at this point, we would need a motion.
I move that
I'll move that there are reasonable grounds to.
No,
Go ahead,
please,
Jeff.
Ed, go ahead.
I'll move that there are reasonable grounds to believe that respondent discriminated on the basis of national origin, namely association with other than a U.S. citizen, and that conciliation should be attempted in accordance with the act.
Second.
So it's been moved and seconded to find reasonable grounds to believe that respondents discriminated against Warren Malcolm on the basis of national origin, association with someone of other than U.S. citizenship. Is there any discussion among commissioners?
Yeah, I just want to say that this strikes me as the forms taking over the universe, that they ask for a social security number and they say, oh, it's the software, and we can't get around that in the face of the Homeland Security and the State Department have abilities to do background checks, and they do them. The assets question, yes, it's not legally proof of ongoing income to say that he could pay the whole thousands of dollars of a year's rent, but it certainly ought to trigger the flexibility to say, well, what other assets are there? And if there are substantial assets, that ought to be a substitution for income. So it just seems to me that they didn't try very hard to get around their own software and their own bureaucratic requirements, and that it was discriminatory.
The other discussion, Commissioner Doosan?
I'm trying to get this straight in my head. So the other thing that's troubling me is trying to connect up, and so I'm seeking advice on this matter. If the problematic practice is a reason, in other circumstances, if the problematic practice is a reason for the outcome, it's prevailing. We count it, even though there were other reasons. So in this situation, if yes, the lack of verification of income, as the respondent argues, was the overwhelming reason, but the lack of Social Security number was also a reason. And that lack of Social Security number question has this disparate impact. Would we weight it higher than, you understand what I'm trying to ask?
Who are you talking to?
I don't know. I believe Barbara.
Okay.
I am not sure I understand what you're trying to say, but I think the question is whether the outcome, well, what we're looking at here is whether the policy has a disparate impact. So you have to show that there was an impact on the individual and on the class generally. And it does not have to be the only reason.
Right. That's what I was trying to ask.
Okay.
Inartfully.
I figured I'd hit on it eventually, but I wasn't quite sure.
Thank you for your insight. Very inartfully. Okay, it's just a question that has had me puzzling around in a couple of different connecting circles. And so thank you very much.
Any other discussion from commissioners on the pending reasonable grounds motion? Seeing none. So the motion is to find reasonable grounds to believe there's unlawful discrimination in housing based on national origin. And if you vote yes, you are in agreement with that finding. Commissioner Whitworth. We have to be able to hear you.
So sorry, no.
Commissioner Ashby.
Yes.
Commissioner David.
Yes.
Commissioner Duson.
Yes.
Commissioner O'Brien. I can't hear you, Commissioner O'Brien.
Yes.
Okay, thank you. So the vote is 4-1. The finding is reasonable grounds to believe unlawful discrimination occurred. So the commission will send a letter to both parties recounting the vote and letting you know the next steps in our process. We appreciate you participating, and the hearing on that case is over. You're welcome to stay on the line, and we're going to move on to the next case.
The next case is a housing case. H21-0132AB, Lorraine St. Pierre v. NFG Housing Partners and Preservation Management, Inc. Is there anybody here for the claimant?
I believe Ms. St. Pierre is here on the phone. Ms. St. Pierre, if you can unmute yourself. Ms. St. Pierre, are you able to unmute your phone? If you press *6, that apparently will unmute you. Thank you, Kit. I've never heard that one before. I'm going to write it down. Ms. St. Pierre, can you press *6 on your phone? So apparently this could take a minute just to, oh, no, *67, Kit, lets you make a call without giving out your number. That one I know.
Okay.
Oh, there you go. Okay.
Yes.
Ms. St. Pierre, you have 10 minutes.
All right. Okay. My lease is underwritten by HUD. Landlord has not created house rules, therefore we have only the lease to guide us. 1, ongoing gazebo case and HUD rules. I'm being discriminated against because I demand my rights according to my HUD lease. This is not a private matter. These rights are shared by all with similar leases. From the moment I took management to court, there was no end to the harassment I received to this very day. Am I treated differently? No tenant at Northfield Green is subjected to what I endure. HUD and I are paying market rate for services we are not getting and others which we reject. 2, disability. Discrimination starts from the very beginning with noise complaints. My disability is used as a bludgeon. I'm being made to obey to specific rules. No, there are no rules. It's whatever landlord's agent decides at any given moment. After the initial noise complaints, I bought myself a laptop so I could work in my bedroom away from complainants adjoining wall. And I got earbuds for my music. But the noise complaints continue. I complain to owners, it doesn't stop. The eviction court points out the discrepancy between these complaints. What's more, judge states that agent has known from the beginning about my disability. Agent issued false complaints about noise to me long after I had corrected the problem. 3, harassment. Once I take agent to court when they renege on their gazebo permission, it becomes a free-for-all, especially once I discover the HUD rules governing my lease and point this out to them. Agent inveigles other tenants. I am being spied on by them and the work crew who report on me for things that are not their concern, has nothing to do with their lives. They are taking pictures of me, making up stories. Agent is breaching my right to privacy in their collusion with tenants about my case. 4, the last minute complaints. On July 17, 2021, opponents handed in files to the commission. The complaints are within the commission's 300 days windows because they only came to light on July of this year. A complaint does not exist if it's not exposed. 5, agent keeps secret files. I've never seen these before. Agents will not inform me who makes complaints against me or any of the specifics. Complaints are not considered allegations, but facts. One never sees the written complaint. I have asked to place responses in my file. It has been refused. They are building a case against me. Complaints about leaving my door partially open, exercising in the common area, windows open, ceiling fans humming, concern mold under the building's floor. Mold spores in my apartment overwhelm me, and I make effort to protect myself. It doesn't rain or snow within my apartment if the windows are open. The building has an overhang. A large common area where I exercise has no apartments facing it, doesn't interfere with anyone. My gazebo does not interfere with others. Agent employee, a regional manager in South Portland, sight unseen, adjures to these incidents she has not witnessed. 6, the mold. Landlord and its agent allows a dangerous and harmful situation to exist at the complex by not eradicating the mold. I have presented enough circumstantial evidence to create doubt about opponents' denial of the fact. 7, the gardens. There are no garden rules in the lease. I had a vegetable garden and agent mowed it down. Their garden rules are erratic. One may have potted plants, this changed to in ground, then again to pots. One needs agent permission, submit pictures of the plants to be used. Agent decides where one can garden. A tenant is given permission for a patio. Why not my gazebo? I did not ask permission for a garden after the new rules because it's not in accordance with my lease. Lastly, I came to Northfield Green with excellent references from former landlord where I had lived for over 2 years. Had HUD rules, the state and federal housing regulations been followed, it would have eliminated all of the complaints I have brought to the commission. I thank you for your time.
Thank you, Ms. St. Pierre. So I'm going to ask the commissioners if they have any questions for you. Commissioners, if you could raise your hand if you have a question for Ms. St. Pierre, and I will call on you. No commissioners are raising their hands at the moment, so there are currently no questions for you, Ms. St. Pierre, but you have 5 minutes left. We will get back to you in a minute after we hear from respondents. So you just hang on there. I'm not going to mute you because unmuting you was too hard. So just hang out there and I'll let you know when it's your turn again. So then, Deb, I'm just going to keep on going. So I saw Ms. Albert is here for, are you representing both respondents?
I am.
Okay, you got 10 minutes.
Thank you. First, I just want to point out that there is a lease and then there are house rules, and I think that those are both part of the record. I'm sure you all have seen them. And they are both, the lease incorporates the house rules, and they are in aggregate the lease. PMI believes wholeheartedly that the investigator has arrived at the correct conclusion in this case after a very thorough investigation. Ms. St. Pierre has given no specific examples of harassment, retaliation, or disparate treatment that relate to any protected class, and she has not shown that the landlord or PMI have treated her differently due to any protected class status. I will address a few of the subjects that the complainant covers in her most recent filing. As you've just heard, Ms. St. Pierre expressed some displeasure with receiving the complaints that other tenants have submitted against her. Those complaints were requested by the investigator and were provided solely as a response to that request and were therefore shared with Ms. St. Pierre. PMI had no intention of springing those complaints onto Ms. St. Pierre, as she suggests. Ms. St. Pierre notes that she's not seen several of those complaints lodged by tenants, but PMI has to make a note of all of the complaints that it receives from tenants. It attempts to address them in a fair and equitable fashion. And if complaints are received but do not rise to an actionable level, they're not pursued. PMI uses its enforcement authority judiciously. And as the district court noted in the FED decision related to Ms. St. Pierre, the management company, PMI, displayed considerable restraint and tolerance in dealing with complaints related to defendant's tenancy. And in that case, Ms. St. Pierre was the defendant. Ms. St. Pierre complains that she's been discriminated against with regard to the alleged mold in her apartment, but PMI appropriately reacted to Ms. St. Pierre's mold complaints by seeking to have the unit tested. They were not allowed, as you've seen in the record, to test the apartment several times, but when they ultimately did so, they had the testing performed by a reputable third-party company, and you've probably seen the mold reports. They were not concerning except for some items that are within Ms. St. Pierre's control. The district court noted in its FED order, again, that after extensive witness testimony, that PMI acted promptly and appropriately in response to tenants' claim of mold. With regard to the FED action, the record before the commission reflects the fact that PMI had ample grounds to bring an FED action against the tenant. And in fact, the court specifically found that Ms. St. Pierre violated the terms of her lease and that NFG would have been granted an FED order, but for the fact that the lease contained an auto renewal term after the incidences of lease violation. The court ruled in favor of the complainant simply because PMI didn't start the eviction soon enough. The court found in its decision that there was no evidence presented to support the claim of retaliatory eviction. Finally, Ms. St. Pierre again alleges that she's been treated unfairly with regard to gardening at Northfield Green. However, Ms. St. Pierre has refused to engage in the gardening procedure required by preservation management, as we've just heard her say. She has not and cannot demonstrate any disparate treatment. The policy at Northfield Green remains uniform. no tenant may plant a garden or place any lawn furniture without first seeking permission of PMI and without agreeing to the landlord's limitations on the common area use. The tenants at Northfield Green rent apartment units. The common area is owned wholly by the landlord, and therefore the landlord can impose reasonable restrictions on the use of that land. After hours of argument and witness testimony, the district court already decided that PMI's enforcement of the gardening policy with relation to Ms. St. Pierre does not support any defense of discrimination or harassment based on any protected activity or recognized classification. The respondents believe that both the district court and the investigator got that right. And that's all I have for now, but I welcome your questions.
Thank you, Ms. Albert. Commissioners, if any of you have a question for, I see you, Commissioner Ashby. I'll start with you, Commissioner Ashby.
Thank you, Councillor. Maybe you said this in your statement, and I apologize if I missed it. What is the reason for the FED complaint on July 14th, 2020?
I would have to go back and look. There were many, but I will pull it up right now.
If it's in the record, it may not be in the record. I'm assuming
it is in the record, and the order, the FED order is in the record. I personally don't do the FEDs on behalf of PMI, so I'm not as, I don't have that immediately.
Commissioner Ashby, I'll just offer, I think the investigator is probably able to answer your question if Ms. Albert is not.
I can wait. I can wait for that, or we can have
Sorry
her
about
answer
that.
now. No, that's fine. I'll wait for the investigator.
Any other investigators have questions for Ms. Albert, for respondents? If you do, raise your hand and I will call on you. I think that clock sound is probably coming from Ms. St. Pierre's phone, which I have not muted. Any other questions from commissioners for Ms. Albert at this point? Not seeing any. We will return. Ms. St. Pierre, we're back to you. You have about 5 minutes left. If you want to use them to present more and respond to anything that Ms. Albert said, you can. You don't have to.
Thank you. Thank you. Concerning the house rules, only landlord can make the house rules according to HUD. Concerning the mold testing that they had done, their conclusion was that there was heavy infiltration of mold in my books, and it could have been caused by some rotting plants. Well, they provided no proof of that, and if there was mold spores in my books, it was also on the sofa, on the carpeting. I offered the filters for my air purifiers. He didn't want to touch that, so it was pretty iffy. Also, I want to add on the eviction. The eviction was not just because the year had turned over. What landlord asked the court was, stated to the court was that since the lease gets renewed, then one can make complaints in 15 years ago, and they're still valid. And the court rightly said no. It goes from year to year, and that's what their decision was. And also, I want to add out that the eviction court made no rulings on harassment. And also, the landlord has not made any rules in the lease about gardening. All the gardening that's going on is according to PMI, which does not have that. According to my lease, it does not have that power to do that. That's it. Thank you.
All right, I think I heard you say that's it. That's where you want to end, Ms. St. Pierre?
Yes.
Okay, thank you. I'll just ask commissioners, any commissioners have follow-up questions for Ms. St. Pierre? If you could raise your hand, I will call on you. I do not see any commissioner questions at this time for you, Ms. St. Pierre. So I'm going to mute you now because that's the end of your time to present. We will go back to Ms. Albert. You have about 5 minutes. Again, you don't have to use them, but you can, if there's anything you want to address.
I would just point out that PMI, I think, as you've seen in the record, is the designated management agent for NFG, and you have that document. So they're authorized to promulgate rules for the property. And I have nothing further.
Thank you. Any follow-up questions from commissioners for respondents? If you do, raise your hand and I will call on you. I do not see that there are any follow-up questions for respondents, so I will also mute Ms. Albert, and we will turn to the investigator, to Alice Neal.
Good afternoon, commissioners. My name is Alice Neal. I was the investigator on this case. Commissioner Ashby, I've been looking through the file to try and find the information that you were looking for so that I could have it at the ready. I was not able to put my hands on it quickly while the presentations have been going on. My memory tells me that the eviction action happened for a variety of lease violations related to the construction of the gazebo, some possible noise complaints, complainant's cat, and both complainant using her window as an indoor and is an egress and place to go in and out of her apartment into the back common area, things of that nature. But with that, I want to reframe this a little because those things are not the contents of my report. The case, as I wrote the report and the recommended findings in front of the commissioners, are based on only two terms and conditions analysis. One is that Ms. St. Pierre thought that she was treated differently than other tenants, and the other was based on her allegation of a hostile housing environment. I have not, a lot of complainants' allegations were outside of the 300-day time period, and or I addressed that the claims were not substantiated in some of the footnotes in the report. So as to Ms. St. Pierre's terms and conditions claim, she thought that she was being treated differently than other tenants, and that was in response to either complaints that she made or response to the mold issues. And the record as it stands shows that respondents, as complainants sporadically made complaints about mold over the course of her tenancy, respondent would attempt to engage with her. And when Ms. St. Pierre said, I don't want you to come in if I can't have 1 or 2 days to be able to let the place air out, otherwise it's not going to be a sufficient result in terms of a test, it's not going to give you an accurate picture, then things would fall off. And in the end, the record bore out a fact pattern that Ms. St. Pierre was a little bit obstreperous and did not allow respondents to come in and do some of that mold testing for a long period of time. There was nothing in the record to me that showed that Ms. St. Pierre was treated any differently than any other tenant. And when you talk about the privileges in terms of the garden issue and what those things are, Ms. St. Pierre hasn't connected that any of the treatment is based on any protected class status that other tenants may be given other privileges that she is not. And while that is something that is separate and aside from anything based on a protected class status. So that's not been established in this case. And then the other piece of the case was that Ms. St. Pierre said that she was alleged to a hostile housing environment because her door was left ajar and her fan speed on her fan was changed, and that her fellow tenants testified against her during the eviction trial that happened in this case. And so in that, there's nothing that she raised that was, that to me said that there was a ongoing hostile housing environment, that these things created anything that was severe or pervasive, and that Ms. St. Pierre, while there have been issues in terms of how she feels that she's interacting with both the management company and the owner of the building, is that they're treating her equally as they are every other tenant. At this point in time, as far as I knew when the report was issued, Ms. St. Pierre hadn't had any retaliatory actions taken against her or anything else. She has not had any lease violation notices issued to her since since May of 2020, and that is outside of the 300-day time period in this case. And so based on that, I didn't find that there are reasonable grounds that Ms. St. Pierre was either treated differently in the terms and conditions of her housing and access to services or the facilities, nor did I find that she was subject to a hostile housing environment. I haven't heard anything today that would change those recommendations, but I'm happy to answer any questions that you have.
Thank you, Alice. Any commissioners, if you have questions for the investigator, raise your hand and I will call on you. I do not see any questions for the investigator. Thank you very much, Alice. And so we've heard from the parties and from the investigators, so we would at this time be looking for a motion or motions.
I'll move the two items together and move that we find that there's no reasonable grounds to believe that respondent unlawfully discriminated and no reasonable grounds to believe that there was retaliation and the complaint should be dismissed.
I think I saw Deb raise her hand, but Deb, since we have someone who's only on the phone, could you do that with audio as well?
Yes, I'm sorry, second.
Thank you. So there's a motion to find no reasonable grounds on both claims, and it's been seconded. Is there any discussion from commissioners? Seeing none. The motion is to find no reasonable grounds to believe that Ms. St. Pierre was discriminated against on the basis of disability in the terms and conditions of her housing, and also no reasonable grounds to believe that Ms. St. Pierre was retaliated against for asserting her rights under the Maine Human Rights Act. If you vote yes, you are agreeing with both of those recommended findings. Commissioner Whitworth.
Yes.
Commissioner Ashby.
Yes.
Commissioner David.
Yes.
Commissioner Duson.
Yes.
Commissioner O'Brien.
Yes.
So both findings are no reasonable grounds to believe that unlawful discrimination or retaliation occurred. The commission will send all the parties a letter confirming this finding, which will outline your options going forward. And you're welcome to stay on the line, but that is the end of the hearing in that case, which leaves us with only one case left to hear.
Which is another housing case, H21-0176 ABC. Piper Stiles v. the Housing Foundation, Duska Haman, and Penquist Development in Bangor. It's a no reasonable grounds recommendation. Is there anybody here to represent the claimant or the claimant themselves?
Yes, I'm here. My name is Piper Stiles. I'm a claimant.
So Ms. Stiles, you have 10 minutes.
Thank you. I first want to say thank you for the opportunity to speak to you today. I appreciate your time. This case deals with the mishandling of two requests for reasonable accommodation and also with a surrounding situation in which the Housing Foundation's discrimination subjected me and my household to the harassment of a disorderly neighbor for an extended period of time. I prepared what I wanted to say today sort of in less of a general sort of overview of the situation and more of a specific response to some things in the investigator's report that I wanted to touch on. So I'll start with those things. The investigator references a local noise ordinance of 10 p.m. in her investigation, in her report, which does not exist. There's no local noise ordinance which cites a specific time. And in fact, I can't find anything in state statute that references a 10 p.m. curfew either. Number two, I provided contact info for two main witnesses, the town manager of Pierceport and the male neighbor whose complaint was apparently addressed, as far as I'm concerned, by the Housing Foundation. The investigator did not contact either of these witnesses as requested. Three, the investigator assumes as a matter of fact that the Housing Foundation had to wait until 3 disorderly conduct charges were made before any action could be taken to evict the tenant. But respondents have repeatedly stated throughout this investigation that they have no protocol or policy in place for dealing with situations like this.
There's been no documentation presented by the Housing Foundation that would support their claim that a rule of 3 disorderly conduct charges is necessary to pursue eviction. Furthermore, the Housing Foundation has provided no evidence that supports their claims that they ever contacted the disruptive neighbor to address the situation. They claim that they sent out letters to her for the noise, requesting the noise be mitigated, but they haven't produced copies of these. And if they had sent these letters out, it would only have provided them with further grounds on which to seek eviction or take some kind of action to make it stop. For investigator references in support of her findings, my service with a cease harassment notice, which is a piece of evidence the town manager and chief of police can testify to as being illegitimate. In fact, they told me to ignore it. This is a document that the PD was harangued and frankly bullied by the disruptive neighbor into composing. And the chief admits that the disruptive tenant who requested this notice lied to him, telling him one was already in existence when one was not in existence prior. She capitalized on her knowledge that the PD had misplaced other documents involved in the situation before. The investigator presents this occurrence as a matter of fact without any context and without having contacted relevant witnesses. 5, my request for a noise policy that was more specific than is addressed in the lease, which already provides that no tenant shall make or permit noise that disrupts any other tenant's quiet enjoyment of the lease unit, does not fundamentally change the nature of the program. That provision about noise is already in there. And I believe that putting a time on it, as I suggested in my ignored requests for reasonable accommodation, does not fundamentally alter the existing program or their policies around noise. I would say combination with the ability to effectively address disruptive noise that was of the nature I was experiencing. The investigator's conclusion that my disabilities were not implicated here is just incorrect. The logic that was used as stated in the report is not compelling. The fact that I stated that everyone needs sleep, nor the fact that everyone does in fact need sleep in any way diminishes the fact that I suffered this situation exponentially due to the disabilities I manage. I was taking a prescription in order to prevent panic attacks and to help with insomnia, and was repeatedly being thrust into sleepless nights and panic attacks due to loud noise, unrelenting thumping bass, agonizing sounds of domestic turmoil from the adjoining unit. And most people would not have been pushed to the limits I was pushed to by this situation, due directly to the disabilities I manage. And as a result of this really incredibly disruptive situation, I experienced suicidality and spiraled with regularity into a state of anxiety and panic that so severely impacted my daily life that I had to leave my job and withdraw from classes. I was suffering, and it was obvious, and the Housing Foundation knew why. This case is not just about ignored requests for reasonable accommodation, although the issues do overlap. It's also about the fact that despite my disability request for reasonable accommodation, the Housing Foundation maintains the tendency of an incredibly disruptive tenant to the detriment of my health and normal use of my leased unit, and ignored my pleas for help despite a plethora of evidence and grounds to evict on the basis that the situation was, in their eyes, nothing more than a cat fight. The situation was repeatedly framed as female infighting. I was told repeatedly, you two, I don't know what's going on between you two, but you need to leave each other alone, and things to that effect. Even after 2 charges of disorderly conduct for noise violations and the conviction of the first charge, it was only on the 3rd charge they alleged that they took any action to remedy the situation. I believe that a more thorough investigation will result in a different conclusion. My case does not rest, as the investigator said in this report, my case does not rest on the statements made by the male neighbor, statements that were not investigated. My case is supported by the Housing Foundation's misconduct in dealing with this disruptive neighbor in general. No notices to speak of were sent to her. No measures were taken at all by the Housing Foundation to make the situation stop. And the very manner in which respondents have sort of obfuscated their way through their defense in this situation, which has pretty much been just a smear campaign against me, supports my allegations that they approached the situation with their bias out in front and dismissed the situation as female infighting rather than actually weighing the facts of the situation in a reasonable manner and treating it as a legitimate issue that it was. That's all for now.
Thank you, Ms. Stiles. Commissioners, any commissioners who have questions for Ms. Stiles, if you could raise your hand at this point. Seeing none at this point. Ms. Stiles, you'll have about 2.5 minutes left after we hear from respondents. I think that's Ms. Rand.
Yes, good afternoon. And I represent all of the respondents, just so that's clear. The investigator had a very voluminous record in front of them, including audio and video recordings, hundreds of pages of police reports, text messages between Ms. Stiles and representatives of both of the respondents. And much of that record is what was available to the Housing Foundation as it was managing through these incidents. And the investigator viewed that record similarly to my clients. And what the record showed was this, that Ms. Stiles has lived in more than a dozen places in the last 15 years and has had difficulty at each of those, and has also had difficulty with another tenant prior to the person that I'll call neighbor, which is the individual in particular at issue here. The record reflects that Ms. Stiles contacted the police many times with respect to neighbor, and the police found the noise, corroborated the noise on only a handful of occasions. It's clear from the record that the police issued Ms. Stiles a cease and desist directive, ordering her to stop filing frivolous noise complaints. And I heard Ms. Stiles, I hear that there's more context to that order and that perhaps that order wasn't fair. But I'd ask you to please put yourself in the positions of the landlord's position, who's faced with 2 tenants who have competing claims against each other.
Ms. Rand, I'm sorry to interrupt you, but I would say please just talk with the commissioners, not directly at another party.
Oh, I wasn't intending to speak. I meant you, commissioners, not
okay.
Ms. Stiles.
Okay.
But noted. The recordings that Ms. Stiles has offered, and those are, there's a significant number of those in the record as well, are not particularly compelling. Most of them don't even reflect noise, but are rather other things that the neighbor is doing that Ms. Stiles takes issue with, including her driving, her parenting, her interactions with other people outside of the complex during the day. Some capture what I think most people would agree are ordinary levels of noise. The record reflects that Ms. Stiles spent a great deal of time and effort recording her neighbor, including going outside at night to record sounds inside her neighbor's apartment, recording her neighbor's comings and goings. In a nutshell, it's impossible on this record to conclude that that neighbor was the only source of this problem. Okay. Ms. Stiles suggests that the Housing Foundation should have credited her complaints. I'll suggest to you that given these disputes, it was appropriate, reasonable, really necessary for the Housing Foundation to defer largely to the police, to law enforcement, and what law enforcement was finding. And what they found were exceeding the noise ordinance, and by ordinance, that's sound after 10 p.m. that's disturbing people. We've been calling it the ordinance. I don't know if it's actually an ordinance or if that's just the standard that the police enforce. All of this, though, goes to whether there's been a nuisance, and that's not the question before you commissioners. The question is whether Ms. Stiles has a discrimination claim. Nobody used the words catfight with Ms. Stiles. That's an editorialization. Okay, there definitely were comments made about this seems to be an interpersonal issue between 2 tenants, for sure. but nobody used the word cat fight. There's just no evidence that Ms. Stiles was treated disparately based on her sex. And as far as disability discrimination goes, I think this is not a disparate impact claim. It's a reasonable accommodation claim. And on 2 occasions, Ms. Stiles requested a very restrictive noise policy, referencing people's cars and televisions being used after 8 o'clock at night. Ms. Heyman prepared a response to the initial request in June 2020, and unfortunately neglected to send that response, though we produced the response itself is in the record. And she denied the request on the ground that would interfere with everyone else's use of their property. Ultimately, while it's unfortunate that that communication didn't happen, it's not legally material because an interactive dialogue happened. There were communications on an almost daily basis between Ms. Stiles and the respondents. And Ms. Stiles hasn't identified an accommodation that they could have provided to her had they talked further about it. The 2 that she's suggested, one being the restrictive noise policy, not reasonable. We agree with the investigator's conclusion there. The other, which Ms. Stiles hasn't come out and articulated as a request for accommodation, but I think implicit in this case, the other is that an eviction of a neighbor. Given the totality of the record, that just was not something that the Housing Foundation could do sooner than it did. I'll pause there and answer any questions.
Okay, thank you. Any commissioners have questions for respondents? Raise your hand. Any commissioner questions for respondent? Seeing none. Ms. Rand, you'll have about 5 minutes left when we come back. Ms. Stiles, you have about 2.5 minutes left. If you want to use them, you don't have to.
Thank you. I think there is some disagreement as to what the Searsport PD's position on the situation was. The Housing Foundation seems to have taken away a very different view of what their position was than I have. And I think that had they been contacted during this investigation, that could have been cleared up. I have had to move multiple times in the last 12 years, and I have not had issues I have not had issues with neighbors ever before moving to Windward Manor. That implication is false. The reason why I've had to move so many times is because I'm stuck in a cycle of poverty, as are most tenants who are living in Section 8 housing. That speaks to, the nature of the housing crisis in this country and various other things. I did request eviction of the disorderly neighbor. There were plenty of grounds. The assertion that I was, recording this person and contributing to creating this situation, it just sort of, I believe it supports my claim. My constant surveillance of this disruptive neighbor, this was not, my having to document the attempt to document the hellish living conditions was not a fun hobby for me. It was not like something that I was enjoying. A call to the police was a panic attack. Like, for me to decide, all right, I have to call the police this time, was, okay, this means I'm not going to sleep tonight. I'm going to be up with a panic attack all night. Their portrayal of me as just unreasonable and that my complaints were unreasonable is unfounded. This tenant has continued to rack up a variety of complaints, identical, they're similar, if not identical to mine, at the property that the respondents moved her to, and has continued to rack up charges along the same lines.
Ms. Stiles, that's your time.
Thank you.
Commissioners, any follow-up questions for Ms. Stiles? If so, raise your hand. Seeing none. Okay, thank you. And back to Ms. Rand. Ms. Rand, you have about 5 minutes. You're welcome to use them or not, or part of them.
I'll use about 20 seconds. I just want to emphasize that respondents appreciate Ms. Stiles' comment about the cycle of poverty. And I would ask you to consider that neighbor 2 may be struggling with the cycle of poverty, and that the approach that the Housing Foundation and Penquist need to take to these situations is sensitive to that consideration. And eviction is a last resort for that reason.
Thank you. Any commissioner questions for Ms. Rand? If so, raise your hand. Seeing none, thank you to both parties. Now we'll turn to the investigator, Alex.
Good afternoon, everyone. My name is Alex Brindley. I was the investigator in this case. At this time, I don't believe I have anything else that I need to add, but I'm open to any questions you may have. Excuse my cat.
I muted myself. Commissioners, any questions for the investigator? If so, raise your hand. Commissioner, questions for the investigator? Seeing none. Okay, thank you, Alex. And so commissioners, you've heard from the parties and the investigator. At this time, we would be looking for a motion.
I'll move. There are no reasonable grounds to believe that respondents discriminated against complainant on the basis of sex and/or disability, and the complaint should be dismissed in accordance with the Act.
Second.
So it's been moved and seconded. Any discussion among commissioners? Seeing none. Okay, so the motion is to find no reasonable grounds to believe that the respondents discriminated against complainant on the basis of sex and/or disability. If you vote yes, you are agreeing with that proposed finding. Commissioner Whitworth?
Yes.
Commissioner Ashby?
Yes.
Commissioner David? Couldn't hear you. Still can't hear you. I can see you, but the rules say I have to be able to hear you. Maybe your battery went. We can't hear you. I can see that you are mouthing, yes, but the rules say I have to be able to hear you. Well, counsel, is that okay if I can see his mouth saying yes, but I cannot hear him?
Let's try this. Ed, are you trying to say yes? I'm going to say that's good.
Okay. Thank you. Commissioner Dussault.
Yes.
All right, thank you. I can hear you very clearly. Commissioner O'Brien.
Yes.
Okay. All levity aside, the finding is no reasonable grounds to believe that respondents discriminated against complainants, and the commission will send the parties and counsel a letter confirming that finding, and that concludes the hearing on that case, and in fact on all of our cases. So
Thank you.
yes, thank you for being here. Commissioners, we already did executive session and there are no votes needed for litigation matters. So I believe we are set for this meeting, and I appreciate it. Everybody, it was a long meeting, a lot of great, good stuff, tough cases, but I believe we are set until we meet in November.
Did I get my microphone back on?
You did.
Yeah, I don't know how it got, the wrong microphone was selected, but I found it, so sorry.
Quick, say yes.
Yes.
It's good. We got you. Yeah, we got you from before. Yeah.
And there is no meeting in October, right? I wasn't sure if I had that right.
Right.
That is correct.
Okay.
No meeting in October. The next meeting is November 8th. And I don't know for sure because I haven't seen it, but I'm guessing it will be a pretty full agenda. I don't know if it will be as much as today, but could be. I haven't seen it yet.
Thank you for a good meeting. And again, thank your entire team for the work you do to brief these cases.
They do a great job. Yep. Good
Move to
stuff.
adjourn.
What?
Move to adjourn.
Oh, unexpected.
Stop complimenting people.
I don't know what to do with that. Was there a second?
Second.
Everybody seconded. Okay. All right. Good. Everyone seconded. And I'm assuming that's the unanimous vote. Barbara tries to vote. Bye. Thank
Thank you,
you.
everybody.
Thank you.
Bye, thanks.
Bye.
Bye.
Okay, Mel, I see your note in the chat. I am not sure.
There, I'm back.
Well, hello. I'm trying to get Mel. Oh, okay. I think we're all set. Okay. Thank you.